Read, Lordship.
For what? To file it and serve it.
Lordship, I paid for had this matter today, Lordship.
Why? What is the urgency?
The urgency, Lordship, the municipal corporation survey notice to demolish the khatal.
They have served a notice. So by merely serving a notice, they will not demolish. They have to hear you and pass an order.
They survey notice, Lordship.
So that is, you file it, serve it, will come next week.
Lordship, they started the demolishing process tomorrow, Lordship.
If they have only served a notice, how can they demolish? There has to be an order.
They serve a notice on 29th March, April, Lordship. Thereafter, we have a verbal conversation between us.
No.
Lordship,
If
kindly.
it was served on 29th April, no.
Lordship, kindly fix this matter tomorrow. Lordship.
May be permitted
File it today, it will appear on Monday.
My lord, I'm seeking my lord's leave.
One by one. Yes.
Check out the report.
2025 for filing this statement from Calcutta, I have given some reference to 16 annual perspective. And kindly see the orders, man.
You are for?
And for the petition. The matter relates to non-payment.
Non-payment?
Non-payment, the non-payment of the tender amount. The work has been completed as per tender, but after completion of.
Very well, you give this slip, it will appear.
May be.
It will appear, no preference, because preference.
May I seek your lordship leave, my lord, for a motion matter, my lord, for inclusion in the list. My lord, in this matter, my lord, in this matter, there was a peremptory direction, my lord, upon the Union of India as well as the State Election Commission to file their, my lord, affidavit by 24/4/2025, my lord. My lord, the same has still not been complied yet. My lord, the matter was supposed to be listed in the month of June.
Very well. Hearing matter, please wait.
My lord, may be.
The day before yesterday, it was in the list and suddenly went out, my lord.
What motion?
My lord, no.
Motion.
Another one was supposed to be.
I'll see, give your slips, I'll see, and then I shall.
My lord, may I be permitted to mention a matter?
Serve notice, but I am not saying that it will be taken up. You serve notice?
My lord, may I be permitted to
No.
mention?
Not that way.
My lord, may I be permitted to mention a matter, my lord, that is running in the list? My lord, that is at item number 143. My lord, this is significantly for hearing, my lord, but my lord, this matter was subsequently decided by the Honorable Supreme Court, my lord.
143.
143. My lord, my urgency today is, my lord, a suit is pending before the learned civil judge Kalimpong, my lord. In this writ, I have challenged the assessment of stamp duty in an impounded instrument, my lord. My lord, if this matter could be taken up, my lord, it won't take 5 minutes of lordship's time because the matter is already decided. The point of law is decided, my lord. It just needs to be adjudicated. My lord, Mr.
Jump. Let us see if we.
My lord, kindly appreciates my urgency, my lord. If
what is urgency? You
my lord, I have
whatever you are submitting, you can submit for the trial court also.
My lord, the learned trial court has waited for significant time since the filing of the writ.
Appearing in the list.
My lord, it's
not again.
I have mentioned this since December.
Over the list. It's not that urgent. Yes.
Kindly consider, my lord.
My lord, may I be permitted to mention one matter?
Ma'am, please wait. No hearing matters right now. There are a lot of hearing matters. I'll indicate in the list when I'll be taking up hearing matters. You mention them. Please, hearing matters next week, not this week. Motion mention. Motion, give your slips.
May I be permitted to mention one hearing matter, your lordship?
Hearing matter, madam, next week. Mention next week.
May I be permitted to mention, madam?
No, madam. Not like that. Not like that. If it was directed to be, you could have mentioned it yesterday, day before yesterday.
No, today speaks for this. That's not in the list. I have given the orders. I see report.
It will appear on Monday. What is the problem? You appear online.
Lordship, may I be permitted to mention one matter, my lord? As my lord just said that no jumping in the list. My lord, what happened? This matter, the 10 analogous matter, my lord, this matter has been heard by Justice Shubhra Ghosh on Tuesday, my lord. The today's call for a report, my lord. Very short matter. Matter has already been decided by the coordinate being chosen. My lord, what happened? When I was traveling from Kolkata to Jalpaiguri, I've heard there is a pin down by the staffs from 2 p.m. onwards, probably.
Where?
In the high courts.
aware.
My lord, the fact is from item number 35 to 45. I beseeching your lordship, my lord, no jumping, but my lord, just to appear in this matter, I came from
Let us see.
Kolkata, my lord.
It is called,
Lordship-
if time is
Lordship,
not
may-
wasted, we may reach also. Yes.
Lordship, may I permit to mention one matter for
Great.
extension of interim order, Lordship.
Then when is it going to expire?
Lordship, already expired on 26th of June,
Then
Lordship.
you take out an application.
I have filed application, Lordship.
File it.
Maybe permitted to mention this matter regarding on compassionate ground, your lordship. Actually, their compassionate appointment ground.
Motion.
Yes, motion stage.
Motion give, I said, motion give your slips, don't mention. Please give your slips.
May I have your lordship's kind leave, my lord, hearing virtually to mention item number 134 of your lordship's list today. My lord,
Yes.
the difficulty is that, my lord, this matter had come up. This is a matter relating to land acquisition. My lord, during the course of the hearing, my lord, the respondents come forward and state that there was an arbitral proceeding that had taken place. So the learned judge, my lord, at that point in time, a coordinate bench of Justice Kaushik Chanda directs the respondents to file a report. Now, there have been 3-4 occasions in the middle, my lord, till date, they have not filed the report. But every time they come forward, they ask for an extension.
Very well.
But
let us
what-
see. It is under the heading hearing, na? I'll be taking up hearing someday this week.
Well,
I
there
mean,
is, this can't be under hearing because, well, there's no pleadings that have been completed.
130,
134, my lord, 134.
134 is appearing as a hearing matter only.
Well, there is no affidavit directions that were given. They were only directed to, my lord, file a report. I was praying
That
only
can
for your
also be a
lordship.
hearing matter. Let us see. It's
But
appearing. I'll
but
not take it
because-
today. It won't jump.
No, my lord, I'm not saying that, my lord. I was only beseeching your lordship for one thing. My lord, what I, my lord, apprehend, my lord, is that the report is not there. I was praying for your lordship to, my lord, keep the matter on at any time, my lord. Lordship doesn't have to keep it today. Lordship, Monday, Tuesday, anytime Lordship fixes the
It'll
matter.
appear
Will
it's appearing in the list already, Mr.
Will
Nayak.
will it be a Lordship's pleasure to, my lord, upgrade the matter? But we'll come for 10 minutes, my lord, because they'll that final, my lord, that direction would be required where
Let us
it's
see
made
how we
peremptory.
proceed. Mr. Nayak, let us see how we proceed. Let us see if we can make some headway. We might reach also maybe in 2-3 days.
But may I be permitted to mention, my lord, one matter, my lord. Yesterday, my lord, I was just mentioning, my lord, one recalling application to your
Then
lordship.
it will appear in the list on Monday.
Great.
I am satisfied that I don't have determination. I'll bring it in the list. I'll give my reasons.
We have a lawsuit
But there has been a notification, lordship has seen that passed by this honorable court, the learned register that the honorable judge sitting in the circuit bench, my lord, will be taking, can take up this review on recalling applications.
I don't think. You show me that notification.
I'll do that. I'll do that.
My lord,
So great, your lordship.
My lordship,
my
may I
lord,
permit to
may I be
mention a
permitted?
matter, my lordship? My lordship, may I permit to mention a matter, my
May I
lordship?
lordship
Petitioner in person in a
mention
lead
one
matter.
Please mention one by one.
We have lordship
Yes,
kindly
madam.
to mention, my lord, this matter. My lord, on 30th of June, my lord, Justice Ghosh was pleased to fix 2 matters under the heading motion for Monday. Now, my lord, this I don't know, my lord,
You
as
give your
because
slip, it will appear. It will
my lord, my
appear.
junior is there, the order is there, my lord. My junior
Very
will
well.
hand over the order. which-
Appear as motion. Yes, next.
Yes, my lord.
My lord, may I be permitted
May
to
I-
mention one matter, my lord? This is extremely urgent, my lord. Relates to illegal detention of Erica Nut by the GST department, my lord. Now, my lord, we have already had one round of litigation where interim order was refused, my lord. Now the matter has become urgent because with every passing day, my lord, the value of the goods are diminishing. My lord, I am led by Mr. Bagh in this matter, my lord. I was only beseeching if your lordship could fix up the matter anytime on next week, my lord, so that Mr. Bagh can
No fixing
physically
up.
come.
You give the list. You give the number. It will appear in the list. No fixing. No upgradation.
My lord, I have had a
Every
word with
matter
the
is urgent for every litigant who has approached this
My
court.
lord.
I cannot give
my lord,
precedence to one over the other.
My lordship,
my lord, I have had a word,
Obviously,
my
all the
lord, with
matters will
the.
be listed. We'll take it in.
My lord,
sequence.
my lord, may
My
I be
lordship.
permitted to mention one matter which is listed as item number 132, hearing matter?
Yes.
My lord, in this matter, a vacating application was filed. They're enjoying stay since 2024 March.
Very
And
well.
this is regarding the operation and management of a church and also offering prayers of a church. My lord, there is one society whose members were running the church since 1969. I am that society, my lord. I am
Madam, your matter is fairly at the top in the hearing list. I'll be taking up hearing
132. My
matters.
lord, kindly takes up any day, my lord. Kindly
Yes,
fixes
yes,
this matter any
I'll be indicating in the list in next week as to when I'll be taking up hearing matters. So your matter will be taken up probably on that day.
My lordship, may I
obliged.
permit to mention a matter, my lordship? My lordship, I am petitioner in person in a matter, my lordship. This matter I am mentioning since last 6 benches, but the matter is not been listed, my lordship. No, my lordship, my matter is of illegal disconnection of electricity from the industry of my father, my lordship, which is the only source of income of my family, my
Which
lordship.
item, madam, which item?
My lordship, it is not been
It's not
listed,
in
my
the
lordship.
list.
No, my lordship, I
Give the
mentioning it
slip,
as
give the
inclusion.
slip, it is a motion, it is at the motion stage, or it has been heard and affidavits have been directed to the
My
same.
lordship, affidavits are exchanged, my lord.
Very well, you give it, we'll see.
My lordship, can I give in the chat box, my lordship?
Give it.
My lordship,
Yeah.
Well, maybe
my lord.
matter, the petitioner is seeking the liberty to withdraw the application as because it lacks
Give it to
jurisdiction.
appear as non-prosecution. Non-prosecution, ye kore debo.
Withdraw the application. my lord.
Very well, it will appear as non-prosecution, on that day it will be withdrawn. You bring your letter from your client, you brought it, bring it on that.
I will bring it in the meantime.
Yes. Non-prosecution is it. Yes.
Item 1. Item number 1. Lord, I am for the petitioner. Here, my lord, I am challenging the goods and service tax matter, penalty order under section 129 subsection 3, appellate order. So, cause that is entire proceedings, my lord, entire seizure proceeding, detention proceeding. What happened, my lord? I am a company of Haryana, trading of heavy goods, heavy vehicles, selling of construction related vehicles. I participated in auction in Assam. The non-banking some loan defender, Mr. Talukdar, loan was at CHN, namely CHN Private Limited, the non-banking financial corporation. I purchased from the non-banking financial purchase corporation, their head office at Haryana, their branch office at Assam. My office at Haryana, I purchased by auction. Thereafter, my lord, in the auction, they issued one tax invoice on 29 September 2023. Thereafter, they filed return, their GSTR1 outward supply return, paid taxes, which is collected from me. They submitted return on 14th October. Thereafter, my lord, my goods movement started from 24th October and it is detained at Jalpaiguri district, Panikauri, on 26th October 2023. At the time of law says, my lord, section 68 of the GST Act and related rule 138 capital A, that I have to fulfill certain condition. Number 1, EOA bill. Number 2, tax invoice or challan. In this case, my lord, this is not like regular supply. This is handover of repossessed goods like machinery, second-hand goods, as per Rule 32, Sub-Rule 5. So, my lord, they issued one tax invoice. I will show your lordship documents later, my lord, first oral submission. Tax invoice. And, my lord, they issued released vehicle release memo. Details of goods. This tantamount to challan. And thereafter, my lord, they detained the goods and issued MOB 01. They said the driver only produced EOA bill, but not recorded that tax invoice, that is E-invoice. E-invoice meaning, my lord, meaning EO invoice when generated automatically reflected in the GSTR1. Tax is already paid. There is no intention to evade tax. And, my lord, thereafter, MOB 2 issued, MOB 4 issued. MOB 4 says that there is no difference. Same goods is carrying. I'm showing you, lordship. Thereafter, MOB 6, that is order of detention, is self-contradictory from the MOB 1, statement recorded in driver MOB 1. How, my lord? My lord, in the one place, they are saying at the time of interception, they produce that sale repossessed documents, that's like tantamount to challan and other 2 documents. But another place saying that after detention, produce EOA bill and other 2 documents. Self-contradictory, how, my lord? The MOB 1, they are saying only EOA bill produce. They are saying no, EOA bill produce after detention. This is self-contradictory. I will show your lordship. Thereafter, my lord, this goods seizure is without jurisdiction because I am carrying EOA bill, I am carrying tax invoice, I am carrying the related challan, that is self-processed release goods memo. And my lord, our division bench in the case of Ashok Sharma held that when there is no mismatch in goods, the MOB4 physical verification, very important document. I will show you lordship. They are saying no difference. Same goods. So when same goods, same HSN, why are the intention of evasion of tax? I am asking myself. Thereafter, my lord, another important submission, my lord, that I made one clerical mistake. Say, my lord, 16 lakh is the goods value. 16 lakhs, two invoice, my lord, two you will. One is, say 16 lakhs 55,000 as per tax invoice, which was submitted in the return. I, while generated, my lord, in the EOA bill, say I gave, I have written 15 lakhs. This is my mistake. This is my clerical mistake. In another invoice, similarly, my lord, there is difference of, in round figure difference of 70 to 50,000. I will show you, lordship. These are the, my lord, brief fact, my lord. Kindly have a look, my lord. First, my lord, at page number 93, my lord.
Yes.
93, my lord, one in tax invoice issued by CNH Capital, Corporate Office, Haryana, and billing to EMP Services, Haryana. And my lord, goods value is, my lord, middle portion. Total base price 12,95,000 plus GST. Second tax invoice, my lord, 94. 16,55,000. The lordship got middle portion.
Where do you get 16 lakh?
My lord, middle portion, total base amount, my lord. Right side middle portion.
Where?
First, your lordship in page number 93.
Yes.
Middle portion, my lord. Right side middle portion. 12,95,000.
That we have got. That is total taxable value.
Total taxable value.
Yes.
Then 94, another tax invoice.
Yes.
16,55,000.
Yes.
Then, my lord, 95, page number. This is vehicle release memo.
Yes.
Number 30476. Dated 29 September. My tax invoice issued on, my lord, 29 September. And release memo 29 September. Two release memo. Next memo, my lord, 96. This vehicle release memo, my lord,
Tax invoice is issued when?
29 September, my lord. Both.
And vehicle release memo is also of the same date.
Same date, my lord.
Where do I get the date of the tax invoice?
Tax invoice on page 93, right side.
This invoice, that is invoice due date and invoice date. Both are the same.
Same date, my lord. Same date.
Very well.
And vehicle release memo date, my lord, left side, second line. 29 September.
Yes, that I have got.
So, if these two release memo, my lord, contain details of the engine number, chassis number, because these goods are backhoe loader, not like regular goods. Backhoe loader. So, one specification is one, engine number written, chassis number written. This is, my lord, tantamount to challan here. And thereafter, my lord, EOA bill at page 97.
Page
97. This is valid EOA bill, my lord, backhoe loader. Here, my lord, written one invoice, one EOA bill written 12,50,000.
Yes.
This is the clerical mistake. It should be, my lord, 12,95,000.
In terms of the first invoice.
First invoice. In terms of the second invoice, my lord, my second invoice value is, my lord, 16,55,000. Here written 15 lakh, my lord. And my lord, next page 99 is the transport documents. Two transport documents, 99 and 100.
Yes.
14 October. Thereafter, my lord, sale possessed assets. Another, they have issued certificate that this is informed that subject asset being number ato. The lordship got page 101. Engine number such and such, chassis number such and such, registration such and such, was deposit surrendered on such and such due to default committed by Sanjeev Talukdar having PAN number such and such, presently residing at Assam such and such. under the loan cum hypothecation
So
agreement,
you are a financing company.
I am not finance, I am purchaser. Financing company is the who issued the tax invoice, CNH. I am EMP Infra. I am purchaser of the this type
You are
of
purchaser from the CNH.
CNH. This is my nature of business. I in all India basis, I purchase and I sell my lot.
So CNH seized it from somebody else who was the borrower upon the borrower committing default, and you purchased it thereafter.
Yes, after auction, auction, my lord. My lord, kindly have a look at page 103, my lord. May I read, my lord?
Page 103.
103. This is MOB. After detention, this is the first, my lord, document. Statement of the owner.
What is this?
This is issued by
MOV.
the statement of recorded by driver.
What is this MOV called? What is the full form of this?
This is my lord, statutory name MOV, movement of goods.
Okay.
So, Parvez, the such and such driver, goods the vehicle number such and such, detained on 26 October 2023. This is important, my lord. So, my tax invoice issued on 14th, and I submitted, my supplier submitted return.
No, your tax invoice is September.
Yes, 29 September. 29 September.
29, you said 14. That's
No,
why.
no, sorry, I committed mistake. I stand corrected. And goods started, my lord, reveal from the OA bill. That OA bill generate on 14th.
Where is the way bill? EWA bill?
EOA bill at page 97 and 98, my lord.
Page 97.
98.
Generated is 14th of October.
14 October, my lord. EOA bill generated. Thereafter, my lord, 5:55 AM, that seized the vehicle, Panikauri under Jalpaiguri district.
Yes.
What written, my lord, in the second page, I am drawing kind attention, your lordship, kind attention, 104.
Yes.
They have written, my lord, middle portion, that consignor CNH Capital, consignee UMP Infra, asset number such and such, EOA bill number such and such. That only recorded here the EOA bill. That tax invoice, my sale repossessed documents, that not recorded. Now, my lord, kindly have a look, my lord, with comparison, MOB 06. Page 114. Starting page, my lord. This is 29 October.
Yes.
I am drawing your lordship kind attention, page number 115, middle portion, my lord.
Page 115.
5, middle portion. May I read, my lord?
Yes.
Order of detention under section 129(1) of the CGST Act rules such and such, such and such. Around 5:55 AM on 26, one goods vehicle bearing registration number such and such was intercepted Panikauri by the official of the Bureau of Investigation North Bengal headquarters Siliguri. During routine website checking, the goods loaded vehicle moving Assam to UP. The driver of the said vehicle asked to produce document being transported. The vehicle driver produced copy of the following documents. A, that 2 copy of the sole delivery documents.
So you say that since this has not been recorded at 104 and it has been recorded at 115, there is a discrepancy.
Yes, they admitted
How
that.
does that help you?
Huh?
How does that help you?
My lord, I have no violation, my lord, because I am carrying with the EOA bill and tax invoice and also challan. And they are physical movements of goods, my lord, that MOV 4, page number 110, my lord.
Page 110.
0. This is very important document, my lord.
Yes.
My lord, this page, may I read, my lord?
Yes.
The physical verification of goods, conveyance bearing number such and such has been conducted in the presence of such and such driver. Physical verification report. Report dated 27 October, vehicle number such and such. My lord, the column, name of the transporter. Tender documents. Tender documents, my lord, these are the challans. These documents, the vehicle release memo, that means tantamount to challans. Chassis number, backhoe loader. But HSN code they have not written. They have exactly written which was written in my EOA bill and tax invoice. Because HSN code is mentioned in the tax invoice, also mentioned in the.
Where is that HSN code?
Yes, my lord. HSN code, my lord. at, my lord, first EOA bill 97, middle portion, serial number 3, my lord, goods details.
Yes.
97, middle portion, lordship got one. 84, HSN number 84295900.
Page
Back,
97.
97. First one 97, second one 98. Middle portion, serial number 3,
Serial number 3. Yes. HSN code.
HSN code. And my lord, similar position, page 98,
Yes,
HSN code.
So what do you say? What has not been mentioned where?
Yes, my lord. And my lord, now my lord, tax invoice. Kindly have a look, my lord. Tax invoice, page 93. Middle portion, my lord. HSN codes. First, second, third, fourth column.
Yes.
So, my lord, the same goods I am carrying, they ought to have mentioned also the HSN code that not mentioned. That means they are admitting the same goods carrying. And my lord, kindly have a look again, page 110, MOB 04.
110.
110.
Yes.
Middle portion, my lord. So chassis number, engine number, backhoe loader, that tallied quantity as per invoice 1, quantity as per physical invoice 1, difference nil. So if the HSN code is same, goods is same, so there is no intention to evasion of tax. And in this regard, my lord, our honorable Chief Justice, decided by our honorable Chief Justice, my lord, Ashok Sharma, my lord, I am relying judgment. Here, my lord. Here, my lord. Same physical verification, no, there is no discrepancy. Same goods carrying, same HSN code, my lord. So after the appellate order, I appeared, my lord, on that matter, and entire penalty quashed, my lord.
Yes.
Now, my lord, I am drawing lordship kind attention. Rule 138, capital A, my lord. বইটা GST বই আছে তো?
Rule 138.
38, capital A, my lord.
Yes.
My lord, may I read, my lord?
Yes.
Documents and devices to be carried by person in charge of convenience. The person in charge of convenience shall carry the invoice or bill of supply or delivery challan, as case may be. Number A. And B, a copy of the EOA bill.
Anyone will do.
My lord?
Anyone will do, either invoice or bill of
Yes,
supply
but-
or delivery.
Yes, they admitted that I am carrying those documents in the MOB 06, though not recorded MOB 01. So I am carrying e-invoice also because e-invoice additional evidence for the portal.
And e-way bill you were carrying.
Yes, e will carrying. Only there is difference of some value. That is of a clerical mistake that I stated in my writ petition. One is around 50,000 and one invoice around round figure 1,55,000.
So how do we know that it is a clerical mistake?
This I committed, my lord, the concerned accounting staff committed, because, my lord, the rule 32 sub rule 5, my lord, this deals with the repossessed documents, some valuation, tentative valuation. So, my lord, the concerned staff, my lord, committed this mistake. And my intention that there is no tax evasion of tax. How, my lord? I am asking.
Before the appellate authority, you said that.
All
It
this
was
said,
it
all
was a
this said,
mistake.
they-
How has it been dealt with?
Yes, my lord. And additionally, my lord, I am only interrupting your lordship. Additionally, my lord, that I mentioned that September 2023 return submitted, because e-invoice automatically auto-populated as per rule 138 sub-rule capital A sub-rule 2. That is auto-populated e-invoice. So additionally, they submitted return on 14th October 2023. My goods moved later than. So at that point of time, government got the tax from me. They collected tax from me.
Tax was on the invoice amount or invoice
In
amount?
invoice as per invoice, tax invoice. Because when tax invoice is correct, only I have clerical mistake of some difference in the EOAB. That does not mean that I am evading tax, because tax already deposited to government. It is additional evidence from my e-portal, my lord. Already submitted by them, they are written. They can easily verify their portal. They are well equipped, my lord. My lord, kindly have a look, my lord, appellate order, my lord. Starting page 164.
164.
164, my lord, starting page. Operative part, my lord, I am drawing your lordship kind attention. Page number 167, middle portion, my lord.
Yes.
Observation, may I read, my lord?
Hmm.
This appellate authority has carefully gone through the fact of the case and submission made by the appellant, memorandum appeal file such and such, such and such. The appellant submit that UMP info is registered with the GST department Haryana, by GST number such and such, having principal place of business as Haryana such and such. And the appellant Manu Talwar is one of the director of the said company who is the consignee of the transaction. Now, my lord, on going through the material available on record, the appellate authority find that the input vehicle number such and such carrying consignment of 2-nose backhoe loader from Borpeta, Assam to Hapur, Uttar Pradesh. Uttar Pradesh is bill to ship, my lord, because they are for export purpose. They mentioned in the documents also, my lord. Such and such. And by CNH Industrial Capital, Haryana, 2 EOA bill bearing number such and such, such and such, such and such. Next page, my lord, 168. It is noted by the adjudication authority in his order of demand that impugned order were being transported under covered invalid documents. So it is noted by adjudication that they did not apply their mind. I will show you, your lordship. On closer scrutiny, it appears that vehicle release memo accompanied with the impugned goods movement in tendered before proper officer is not delivery challan. They are saying this is not delivery challan. My lord, this is guided by the rule 32 sub rule file. I will show, my lord. This is not regular tax invoice. But tax invoice there, they admitted. But this release memo is tantamount to challan. So I covered by the or 138 capital is first part, my lord, that e-invoice that is generated through portal. Second, my lord, it appeared to be release memo only respect of backhoe ladder for release of the goods from the stock yard or kept repossession of the borrower. Same released memo. And they referred, my lord, rule 138A, next page, and 169. And, my lord, may I read, my lord, 170.
Yes.
As per procedure as laid down provision 129 of the Goods and Services Act, related Central Act, rule frame thereunder, a penalty is only when infringement of provision of the in the Act, rules framed thereunder established as per physical verification and the veracity of the document accompanied by the consignment. The case law cited by the appellant are not found even in the instant case, since the language of the statute is no liabilities or to establish mens rea, it is wholly unnecessary whether such violation of law willful, deliberate with intention to evade tax. And, my lord, they confirm the penalty. They did not apply their mind. They did not analyze the entire factual position of the case, legal position of the case, my lord. This matter, first part of the submission. After learned friend submission, if required, my lord, I will submit, my lord.
Yes, madam.
May I draw your lord's attention to the appellate order? Page number 160.
Yes.
The order is dated 28/3/2024.
Yes.
And the appeal was filed, sorry, the writ was filed on January 2025, after a lapse of 9 months. But if they go for, before the appellate tribunal, under 112, the time period suggests 3 months. So first they are supposed to explain the delay in filing this writ petition, and in their petition, nowhere they have explained that delay. But first contention, but second contention. Now, the lordship sees rule 138A. My lord, it clearly says that he has to carry an invoice, bill of supply, or delivered challan. Now, my lord, lordship sees the appellate's order in page number 168. The reason is given in 168, my lord. It starts in the middle portion. The delivery challan is required to be accompanied with the goods in case of movement of the goods for reason other than by way of supply. So it is their case, and it's prescribed under Rule 55. So they are supposed to comply with the provision of Rule 55 first. But in the present case, there was no such delivery challan accompanied with the goods. It was found to be a vehicle release memo, which they have annexed, my lord. Vehicle release memo, they have not.
But does the vehicle release memo not satisfy the requirement of
There are
the challan?
criteria for delivery challan, my lord, which is stated in Rule 55, my lord, and which says
Rule 55. Yes.
firstly, it says transportation of goods without issue of invoice. That is their case, my lord. It says the consignor may issue a delivery challan, serially number not exceeding 60 characters in one or multiple series, in lieu of invoice at the time of.
No, why do we say transportation of goods without issue of invoice here? Invoice was issued.
My lord, they did not carry the invoice. They have declared in their e-way bill as a challan, my lord.
The invoice was there on record,
My
isn't
lord,
it?
if you talk, that's why I'm saying, my lord, e-way bill, page number 97.
Page 97.
They declare document details as challan, my lord. That should have been
Where is that?
document details in middle portion, document details.
Goods detail transfer.
Approximately, this says there were.
Page 97.
Page 97.
The e-way bill details is
Yes.
there.
And
Then
this is
address details.
middle portion over here.
Then good details.
Document details. At the top, my lord.
Oh,
Top
third
is
line,
e-way bill details.
third line, third line.
Third line.
Document details. Challan.
Ah.
Got it.
And what is challan number, my lord?
476.
It is the vehicle release memo. That is the vehicle release memo number, which they have provided in the e-way bill. That is in page
So
number
that they have
90.
treated as delivery challan.
That they are treating as delivery challan. That cannot be done, madam.
But for a vehicle release, you have a separate challan.
Madam, they have to cover it by the provision of law, madam. There must be a separate.
No, if it
delivery
is substantially, what is a challan? A challan is a permission to take, right?
Right.
So if this vehicle release memo serves the purpose substantially, then maybe it's not in the letter of in accordance with the letter of the provision, but it is in accordance with the spirit of that.
Might be, my lord, but it also has to satisfy certain condition, which is provided in Rule 55, which if it is not provided, my lord, then it will not be acting as a delivery challan. So for example, the date and number of the delivery challan, name, address, goods, service tax identification number of the consignor, if registered, name and address of the goods, identification number of the consignee if registered.
All these things are not there.
All these things are there.
If it satisfies the conditions, madam, then in that case, delivery challan only because the name is different. Will it not, because the authenticity of this document,
Provisions have not been complied with.
page 50, rule 55,
Five.
rule 55. What are the requirements of a delivery challan?
My lord, name and address is done. Harmonized system of nomenclature code and description of goods, my lord. HSN code, my lord, that is not given. Taxable value, my lord, that is not given. Tax rate and tax amount, my lord, not given.
HSN code is there in the tax invoice.
Tax invoice.
Yes.
Tax invoice he was not carrying.
That's the thing.
But
And it doesn't also suggest what's the tax value, tax amount, nothing, my lord. If the lordship sees the vehicle, which is minimum.
So if he produces it subsequently, will the authority not consider even then?
My lord, if there is a violation of the provision of law, 138A, my lord.
See, violation of a provision because he doesn't have it is one thing.
My lord.
Violation of the provision because he did not have it at that point,
My lord, we do
but
not
he
know
had
the
it.
intention of the person, because even the amount of
Intention
the
will only
amount-
matter if there is intention to evade.
the amount of goods was also different, my lord. The tax invoice suggested some different amount, whereas, my lord,
That
this
is,
is another question, my lord.
that is traveling.
that
That's
is the
the-
only question.
My lord.
Other questions,
We have opposition because there is a,
Mr. Rai, I think affidavits should be invited on this at least. Because that is an important question, because you don't
Only,
have
I am
it.
also, I must
You-
assist
you-
your lordship.
You don't have the invoice.
No,
Must-
yes, yes.
Did not carry it then.
No, they recorded MOB 06, my lord. Yes, that is my condition. This self-contradictory. Kindly have a look, page 115. That is self-contradictory, their statement. And in additionally, my lord, that invoice,
Where,
in
page 115?
115 middle portion, the 2 copies of the sold document, such and such, this is the release memo. And my lords, thereafter 2 copies of the repossessed documents. Thereafter, my lord, written that after issuance of the MOB 01, before detention, they produce consignment note and 2 copies of EOL. Entire statement is
But invoice
con-
is not there still.
no, tax invoice not recorded. That means, my lord.
No, but tax invoice you have not produced, that means even
No, my lord.
subsequently.
What happened, my lord? In the MOB 1, they are
No,
saying.
but Mr. Rai, I have to at this stage judge it on the basis of the documents that you have produced before me.
Yes.
From the documents that that you have produced and which are according to you your best documents,
Yes.
those also don't show that you had the tax invoice then.
Yes.
You
As-
might
as
be
per
having it
record.
in your
Yes.
custody, but the records before me don't reveal that you produced them before the authorities, right?
My respect.
And the problem is
Yes.
that the discrepancy is with regard to the amount in the tax invoice.
Amount that is traveling, my lord. That is traveling. Yes, I am also admitting. But my lord, this
Madam, how soon can you file your affidavit?
fix, my
The tribunal is not functioning.
no, my lord. That is why there is no delay, my lord, because tribunal till date, my lord, not.
No, delay is there.
No, my lord. That is, my lord. Tribunal says, my lord, after appellate order, when the tribunal forms, tribunal rule says so, notification
Which rule?
says
Which
so.
rule? Show
No,
me.
I am
just
not.
want to learn it.
Yes,
Show
yes,
me.
yes. That after formation within
Show
3 months.
the rule. Show the.
My lord. Rule 112. I'm checking now. No, section 112.
Section or
Section.
rule?
No,
Section
section.
112.
I am not carrying the relevant notification, but this is latest book I am carrying. Yes, madam. 112, madam.
1
May I read, madam, subsection 1?
Just a minute.
within 3 months from the date on which.
Your lordship books is 25.
No, 23.
23. Then, my lord, from I am providing a lordship state GST current edition, madam.
That I think I also must be having.
No, this is the current, the few days
Yes.
ago. This is the edition of few days ago.
Yes.
State GST. Learned friend might have
All right,
found it.
fine.
আমার সিদ্দিকী স্যার দিয়েছেন আমার May I read, my lord?
Section 112.
112. This is perimeter provision, my lord. I have the book of CGST
No,
or
I
lordship.
understand. It has to be perimeter.
Perimeter. Section 112.
Or the date as may be notified by the government on the record.
Yes. So, my lord, after notification within 3 months, after the section 107 order,
This was inserted in 2024.
24. That is, my lord.
Very
There is no delay, my lord.
Very well. Little.
First appearance before your lordship.
Thank you.
I'm good.
Thank you.
Lordship, on item number 4, I'm
on behalf of
led,
the petitioner.
led by Lane Deja, Dhiras Trivedi and Origit Chakraborty online, Your Lordship. Respondent number 4 and 5.
But item number 4 and 5 are substantially not similar, but I don't say not it is identical. Because blood once I make my submission on item number 4, blood in substance it might cover blood at number 5 also. But the nature of the order which I am challenging, blood the nature of the order differs. But I'll make that submission blood in course of my blood submission before your lordship. Now blood in this matter, the item number 4, I am challenging blood a freezing order under section 17.
Mr. Mukherjee, there is a provision for appeal against.
No, blood, not at this stage. Not at this stage. Because blood, I am equipped with judgments of this honorable court, Calcutta High Court. And blood, I can always blood point out before your lordship as to the procedure of blood the freezing or blood the search and seizure not in accordance with law.
That you can always do, but
Yes.
this is appealable. This is an appealable order.
No, this is not at this stage. It is not. Why I say blood? Yeah. First of all, blood, I am a person who blood came into operation of the tea garden pursuant to a standard operating procedure blood floated by the government of West Bengal in respect of closed tea gardens.
Directorate online. I'll be taking the point of maintainability of these writ petitions.
Now, blood, the SOP
Should
was
I
floated.
hear you first then if he's taking the point of
But let him, Lord, before your lordship, Lord, hears him, your lordship will kindly have an ambit of this matter. Otherwise, Lord, it will be quite out of context, Lord.
Right.
Now, Lord, I came into this particular, Lord, the tea gardens for its operation and revival pursuant to the, Lord, the statement of objects and purpose that was floated by the government of West Bengal. There was an agreement in 2023 with my client, who is now Lord operating the tea gardens and Lord the labor union there, because Lord the dominant purpose was Lord to revive the tea gardens, and Lord there are about Lord more than 1,000 workers who were languishing at that point of time because of the closure of the tea gardens. So Lord, after I came into Lord the operation of the tea garden, Lord there were Lord the statutory licenses. There are a number of statutory licenses are required to be Lord taken for operation of a tea garden. Now, Lord, I have obtained, Lord, the statutory licenses, the permit from the government, and Lord, I was operating this tea gardens. The plantation laborers were all happy. Now, Lord, on 30th of May, Lord, there was, Lord, a notice given to me after, Lord, a search was conducted to say that, Lord, the particulars contained in the notice, which are in annexure, the machineries, the tractors, even an ambulance, Lord, these are, according to, Lord, the authority are, Lord, purchased by proceeds of crime. Now, Lord, these were not freezed, not Lord, these were not Lord attached or not seized. Because Lord, the distinction I'll put before your lordship, Lord. And Lord, the procedure of seizing, Lord, that they have done, I'll also point about that. Now, Lord, my first point before your lordship is that, Lord, if your lordship kindly have a look into Lord section 17. Boita though.
My lord, my lord, I am not intending to interrupt my learned senior friend, my lord. My lord, I beg to appear for the enforcement directorate.
Yes, Mr.
Sir, I'm not intending to truncate the arguments of my learned senior, but my lord, I just want to point out, even for the knowledge of my learned senior friend, that we have issued a provisional attachment order in respect of these properties on 21st of June 2025. And therefore, the maintainability point we were trying to raise at the very outset. So my learned senior friend should also address the Honorable Court on that provisional attachment order.
But that has not been Lord issued to my client. My client did not receive it. Lord, when the writ petition was filed, at least Lord, I can say that this was not before Lord the court.
It was not done at the time when the
I
writ
am
petition was
challenging.
filed. But then after that, since accommodation was sought for by the petitioners 2 weeks before, when the matter appeared before this Honorable Court. So in the meantime, we have proceeded further and we have issued an attachment notice, and now their remedy lies with the adjudicating authorities under the PMLA Act.
Let them come up with an affidavit then.
Yes, I will come up with an affidavit.
Let them come up with an affidavit. In the meantime, why I require an interim order? Why I say this? Lord, kindly have a look into the freezing order.
If attachment
No.
order has already been passed,
My lord,
if attachment order has been passed, on this what interim order will I?
Lord, I will just, your lordship will kindly come to Lord, page 90.
90.
90. But after the freezing, Lord, they have attached it. The reasoning is not same. If the fundamental
That
reasoning of
order
that
will
freezing order is, Lord, if I can show is faulty, my learned friend's contention that whether I go before the adjudicating authority or not, that is a secondary question. But I am entitled to, Lord, an order on the freezing. Whereas I, Ramchandra, Assistant Director, Directorate of Enforcement, have been duly authorized by Sri Arun Gopal Pandey, Deputy Director, Directorate of Enforcement, VD authorization number 60 dated 29/5/2025 to conduct search and seizure. Lord, each of these words, your lordship will mark, and thereafter, Lord, I'll rely upon a Supreme Court judgment and a Calcutta High Court judgment. To conduct search, seizure, freezing under Section 17 of the Prevention of Money Laundering Act at the premises of Bamundanga and Tandu Tea Estate Private Limited. And whereas during the course of the said search and several items such as machineries, vehicles, and bungalows, as detailed in Annexure A, were found and identified as being relevant for the purpose of further investigation under provisions of PMLA. And whereas it is not practicable to seize the said items of machinery due to their nature, size, and location. Now, therefore, in exercise of the powers conferred under Section 17(1)(a) of the PMLA 2002, I hereby order the freezing of the machinery listed below to ensure their availability for investigation and to prevent any unauthorized use, transfer, or disposal. It is hereby directed that no person shall remove, part with possession, or deal with, or otherwise dispose of the aforesaid machinery in any manner whatsoever without the prior written permission of this office. Any contravention of this direction shall be deemed to interfere with the due process of law and may attract legal consequence under the Prevention of Money Laundering Act. Thereafter, my lord, the list at page 92. Now, my lord, your lordship will see, my lord, that all the machineries concerning, my lord, the tea production are, my lord, the subject matter of freezing. Now, my lord, your lordship will kindly come to my prayers. What I am asking for by way of an interim relief. But if in respect of, my lord, a particular tea garden, if the machineries, my lord, are freezed, my lord, the order of freezing, does it mean, the question I asked to Mr. Trivedi, that I will not be, my lord, able to use the machineries for the purpose of production, or that I cannot deal with the machineries by sale? Because once I take your lordship, my lord, to the definition that what is intended basically by freezing, my lord, I will show that the authority has added words to, my lord, the order that has been passed. So, my lord, your lordship will kindly come to my prayers at page 23. And then, my lord, the interim order directing the respondent to not to give effect to the word deal with in the freezing order dated such and such to allow the petitioner to continue with plantation activities till disposal. So, my lord, as of now, today, whether I go before, my lord, the appellate authority or not, but I have to run the tea garden. All the plantation laborers are looking at my face for their livelihood. The Lord, slap a freezing order. Very well. The purpose of, Lord, the PMLA is to, Lord, appropriate from, Lord, the asset that deem, Lord, that purchased from the proceeds of crime by selling it and take the money. But I have got twofold, Lord, suggestion to my learned friend. First of all, Lord, by an interim order, I should be permitted to, Lord, use the machinery, not to sell it. The machineries which have been particularized in the notice. Secondly, my lord, the purpose of, my lord, attachment is, my lord, ultimately sale. I can also do valuation subject to the outcome by the adjudicating authority of the special court of the machineries to, my lord, have an idea about what is the value of, my lord, the machineries are there. These are 50-year-old machineries. I only came into operation in 2023. I've appended all documents to show that. They are trying to, my lord, fix, my lord, a liability of a PMLA, my lord, a crime under money laundering against another gentleman who is not my client. One Mr. Prashanna Kumar Roy. So, my lord, this particular order also, my lord, suffers from procedural irregularity in the nature that your lordship will find if your lordship kindly have a look into the, my lord, the statutory provision. Section 17 first, and my lord, thereafter I'll take your lordship, my lord, to the rules. There is a rules, my lord, concerning, my lord, the search, seizure and freezing. My lord, search, seizure and freezing, these are not, my lord, interchangeable words. They have their separate connotation. Now, my lord, section 17.
Yes.
Where the director or any other officer not below the rank of deputy director authorized by him for the purpose of this section on the basis of information in his possession has reason to believe the reason for such belief to be recorded in writing. Not kindly mark this is the first ingredient. Why? The person who goes and freezes is not the director or the deputy director, but he has been authorized by the director and the deputy director. Kindly come to, my lord, that particular, my lord, order at page 90. This authorization number 60 of 29/5/2025 is never appended nor given to my client. Because that is where, my lord, the subjective satisfaction of, my lord, the director or the deputy director has to be written to confer an authority to a subordinate to conduct the search and seizure in the manner contemplated in the statute. Nowhere, my lord, from the order that I challenge, the freezing order, your lordship will find that that has been, my lord, supplied to my client.
Yes.
Secondly, from this particular order at page 90, your lordship will not find, my lord, that the basis of information and, my lord, the satisfaction that, my lord, that they are proceeding for search concerning, my lord, a particular property which they believe to be, my lord, a property purchased from the proceeds of crime, that is not reflected. Section 17(1) III and 4. These are, my lord, the prerequisite. You have to first be satisfied yourself about this. Then only you authorize. Then, subject to the rules made in this behalf, he may authorize any officer subordinate to him. Then, Lord, 1A is what, Lord, they have exercised. Section 17, 1A.
Yes. Where it is not practicable.
Where it is not practicable to
Proof
see
tenants.
such record or property, the officer authorized under subsection 1 may make an order. Make an order to freeze such property whereupon the property shall not be transferred or otherwise dealt with. So otherwise dealt with, not is to be interpreted ejusdem generis with transferred. So the dominant purpose of freezing is that you don't liquidate the property.
No third party interest will be.
That is not the dominant purpose, because Lord, for all attachment, for all freezing, is that if it is found that it has been purchased from proceeds of a crime, I will sell and realize the money. In the interregnum, if I don't use this, Lord, for the purpose of production, Lord, that will be, Lord, an antithesis to the purpose for which I have come into, Lord, this operation of the garden. The workers will be at limbo.
And what is the effect of attachment?
But the attachment is not the stages, because once it is attached, there are provisions for the attachment. It goes to even after the freezing. They have to report under subsection 4 before the adjudicating authority, but within 30 days.
Can they not attach without freezing?
They
can.
So far, under section 17, this only constitutes
No, suppose Mr. Mukherjee,
My lord.
let us assume on the face value that this freezing order is illegal. Suppose.
Lordship.
Then also if they can attach, for example, if attachment is not a stage which is to be preceded necessarily by freezing, then in
Lordship.
that case, even in the first instance, I can attach. If I could have attached even at the first instance, and there is an order of attachment, then notwithstanding this order of freezing being legal or illegal, whatever, the attachment order remains. How will I that now?
I will try to assist your lordship. So far as before your lordship, it is only from Mr. Trivedi that comes that they have passed attachment order.
But-
I have not seen that attachment order. Whether
Because
it has whether the
that is
text of that
important,
attachment,
Mr. Mukherjee, at this stage,
lordship.
I will not be able to ignore this submission that
Very
there is
well.
an attachment order.
Very well.
Now, I am at the moment with you that prima facie reading of this section shows that yes, freezing would mean not allowing the person concerned to deal with the property in such manner that a right contrary to the right of the person who is the owner is created. He will not transfer it, he will not alienate it in the sense in which we understand transfer.
Lordship.
But if a stage of attachment has been reached, where all of this is taken care of, it becomes sort of custodial legacy. Then in such a case, this freezing order becomes irrelevant today. Now I have exercised a greater right. I have taken the property under my control fully. There,
I appreciate what is playing in my lord's mind. Now, only that I need to see to answer your lordship is that, whether, the attachment order speaks of the fact that it has preceded with the freezing or not.
no. Whether
If it
the
is
attachment-
independent,
Whether the attachment is legally required to be preceded by freezing. Because if Mr. Mukherjee,
but it is generally not.
so if it
Generally
is not, and I have exercised that right,
Lordship.
see, maybe even if it was, I have two rights, a smaller right and a greater right. The greater right is subject to my exercising the smaller right. In that case, if the exercising of the smaller right is wrong, the exercise of the greater right will also be annulled on that
Lord-
ground alone.
Lordship.
But if I have a right to exercise the greater power at the first instance, then whether or not I have exercised the power in the intermediate stage in a wrong manner, that becomes irrelevant. I have
But
exercised that power, that needs to be challenged.
I understand what is playing in my lord's mind. In the interregnum, since I am challenging before your lordship without the knowledge of the attachment order, the freezing order, as of today, let Mr. Trivedi
Bring
produce
that on.
before your lordship the attachment order with a copy to me.
Yes, yes.
I can come back to your lordship next week, to apprise your lordship.
Yes.
In the meantime, kindly clarify that will not mean that my client is not going to sell any of the attached property.
Mr.
or not
Mr.
the freezing
Mukherjee,
property.
without seeing the attachment order, I cannot, because
But
then I
even
will be
for the-
interfering with the
Even
attachment
for the
order.
attached property, my lord, the property is only attached. And it is
Attachment-
custodial legis, it is in the custody of my client, it is not in their possession.
That-
All that I say is
the
that, my
language
lord,
of attachment now, because
kindly see if they are attaching an ambulance, if they are attaching, my lord, the vehicles in a tea factory, that comes from instance.
That Mr. Chatterjee, Mr. Mukherjee, depends on the language of the order of attachment. Now, you also know, for example, if a receiver is in symbolic possession, then the
Lord.
property does not go in the possession of the receiver.
My lord.
It remains in the control of the person who is the owner of the property or at the helm of the affairs of the property. The receiver is only in symbolic possession. That is one form of attachment.
Lordship.
Now, if it is attachment such that I take total control of the property, for that the order needs to be seen. I must see the order before I proceed further.
Very well. Then your lordship will kindly, my lord, direct
fix
Mr.
the date.
Trivedi, my lord, to
Yes.
serve as a copy, my lord, the
Lordship,
attachment
one more
order.
point. My lord, one more point I would try to make out, my lord. Why on maintainability we were arguing, my lord? What is the locus standi of the petitioner? My lord, will first, I'm asking a question to myself. This particular properties were purchased by one Prashanna Kumar. My lord, will kindly, Prashanna Kumar
No
Rai.
tea gardens can be
Who is
purchased.
the
These are all
charge
government
sheeted-
land.
My lord, may I? My learned senior friend has made his submission. I should also get the right to audition. Now, my lord, Mr. Prashanna Kumar Rai has been charge sheeted in connection with the scam of School Service Commission. Now, my lord, out of the proceeds of crime, he had got
Not proceeding.
these T states.
Is now.
While he was charge sheeted, he was behind the bar. Lockout notice was issued. Now, taking advantage of that lockout notice, since nobody is there, the petitioner steps into his shoes, suo moto, from where he derives the right, God only knows. The documents, he's saying that it is his property, and he's challenging attachment and he's challenging freezing. What is his local standing? Now that property doesn't belong to him. He is not even the lessee of those tea estates. He is not the management. He has taken up that particular tea estate because of an agreement with the Trinamool Congress Labour Association, which allegedly, my lord, represents some of the laborers who are working in that tea estate. How many of them, we do not know. Now, by virtue of that particular agreement, he has usurped the right of management, and now he is managing and drawing further money and drawing usufructs from a property which is purchased or have been established from proceeds of crime. Now, Miller, the situation is such that who is he? He is not even entitled to get any notice. If I am the owner, he is a trespasser, rank trespasser, on a property which has been purchased from proceeds of crime. Now, Miller will kindly come to the annexures from where he gets his right.
Page 31.
Kindly come to the petition itself.
Page 31.
My lord will kindly see the petition. I am the first placing before my lord paragraph 2 of the petition. Your petitioner states that the erstwhile management of Bomondanga and Tudu Tea Garden situated as so-and-so issued lockout notice with effect from 4/10/2023 citing poor financial condition which led to deprivation of the workers at the tea garden of their statutory dues and wages. After much deliberation, the petitioner company took over the management. How? Of the said tea gardens and accordingly entered into a bipartite settlement with workmen of the tea garden. Now that I will show, that is annexed. That does not give him any right. Then my lord, he says, your petitioner state that the petitioner company had obtained registration in terms of section 3B of the Plantations Labours Act issued by assistant labor. My lord, that registration anybody can get. That does not give him a right. So my lord, take over the management. Then my lord,
properties.
Then, my lord, your petitioner states that the Department of Land and Land Reforms, Refugee Relief and Rehabilitation, so-and-so, issued a notification bearing memo number so-and-so dated 6/11/2024, later published this Kolkata Gazette containing a detailed standard operation procedure, intending for the purpose of ensuring that tea gardens within the state of West Bengal remain operational from securing socio-economic development of North Bengal, as well as protecting the revenue of interest of the state. Your petitioner craves leave to produce this SOP. Now, Miller, so his right flows from the fact that he has entered into an agreement with the association.
Page 31.
That is at page 31, Miller. Now, Miller will kindly see what right does the association has to give the petitioner the authority to run the machineries, to run the show, earn profit therefrom. Who has given the right?
Para 4.
Now, Miller will kindly appreciate, and the notification. First, my lord will kindly see page 44. This is the merchant. Now, my lord will kindly see the agreement. Arijit, please help me with the agreement. Which
page 31.
Page 31, my lord will kindly come.
Yes.
My lord will kindly. I render unqualified apology, my lord. I am using a tab, my lord. I am technologically handicapped.
Use liquid text.
Malad will kindly come to page
31.
31. Yes.
No, not 30.
Memorandum of settlement.
Yes, my lord. Ma'am. Now, my lord, here, my lord, in my 30, my lord, the settlement is between, my lord, Merchant Monger Agrotech Private Limited, so and so, with
Trinamool
Cha Bagan. Now, my lord, this, and now the notification which my learned senior friend is which has been stated in the petition.
I will take leave from my learned senior. My lord will kindly take para 4 at page 31 for once.
Short
Para
recital.
4. Para 4. My lord,
Short
para
recital of
4,
case.
yes, on the same page.
Yes.
Short recital of the case. My lord will kindly take sixth sentence, right hand side. Sixth sentence, right hand side, no objection.
No
Your lordship,
objection.
my lord, kindly read that sentence, that they have no objection regarding plucking and selling of green leaves. My lord, kindly mark that. So what is the agreement all about? Agreement all about plucking and selling of green leaves, which does not require any plant, machinery, vehicle, bungalow. So the agreement was only to pluck and sell green leaves. By the virtue of this agreement, the petitioner before your lordship demands that he is the owner of everything and he is challenging the freezing order, and now there is an attachment order, and even without taking recourse to all the statutory provisions provided in the law. Your lordship was
But
looking into,
Mr. Chakraborty, it was submitted that this order of freezing is not appellable.
I'm coming to that, my lord. I'm coming to it. My lord will kindly take section 17. Your lordship was looking into section 17. Kindly take it for once from me.
Yes.
My lord, section 17 has two parts. The first part talks about, let me read it for your lordship, where the director or any other officer not below the rank of deputy director authorized by him for the purpose of this section on the basis of information in his position has reasons to believe that reasons are for such belief to be recorded in writing that any person, now number one, has committed any act which constitute money laundering or is in possession of proceeds of crime involved in money laundering, or is in possession of any record relating to money laundering, or is in possession of any property related to crime, then subject to the rules made in this behalf, he may authorize any officer subordinate to him. Madam, I am stopping here for a moment. So the first part talks that the deputy director or above, officer, deputy director or above, has a reason to believe that any person is in possession of the proceeds of crime involved in a money laundering activity, he may authorize any subordinate officer. So the first part ends here. Second part, the officer subordinate is entitled to enter and search any building, place, vessel, vehicle, or aircraft where he has reasons to suspect that such record or proceeds of crime are kept, break open the lock of any door, box, locker, safe, almirah, or other receptacle.
Yes, Mr. Chakraborty. I have read that, Mr. Chakraborty.
Correct. So, my lord, the second part authorizes the subordinate officer to seize, that is clause C. Here, what has happened? The deputy director has formed his reasons to believe. From page 90, your lordship has seen that deputy director has issued the authorization, the particular authorization number 60, dated 29th May 2025, to the assistant director to go and do the search. During the search, the assistant director found that these properties are out of proceeds of crime. These properties were purchased by Prasanna Kumar Rai and his wife. My lord, I am giving the name in detail, my lord. The Prasanna Kumar Rai and his wife Kajol Soni Rai. There are total 3 tea estate companies where they have invested the money, the ill-gotten money from the SSC scam. In the SSC scam, your lordship is aware of that already more than 25,000 people have lost their job by the dictum of the order of the Honorable Supreme Court. Now, from that ill-gotten money which has been invested in this particular plant, machinery, vehicle, and bungalow. So this is a part of proceeds of crime in terms of section 2(1)(u) of the PMLA. So he has seized it. But since this is not practical to seize and bring them, he exercised power under subsection 1A. That's a freezing order. Now your lordship will kindly take section 20.
1206.
My lords, the act itself provides a complete mechanism. Kindly come to section 20. And particularly subsection 3. Subsection 1 first, my lord. Where any property has been seized under section 18 or section 17 or 18 or frozen under subsection 1A of 17, and the officer authorized by the directorate in this behalf on the basis of material in his possession, reason to believe that reason of such belief to be recorded by him in writing, that such property is required to be retained. Kindly mark the word is required to be retained for the purpose of adjudication under section 8. Such property may, if seized, be retained, or if frozen, may continue to remain frozen for a period not exceeding 180 days from the day on which such property was seized or frozen, as the case may be. So, my lord, the validity of section 17(1)(a) order is 180 days. Correct, my lord? Now, your lordship will kindly take subsection 3. On the expiry of the period specified in subsection 1, the property shall be returned to the person from whose such property was seized or whose property was ordered to be frozen, unless, kindly mark, unless the adjudicating authority permits retention or continuation of freezing of such property beyond the said period. So, my lord, the mechanism is, after freezing or seizure, I have 180 days, by which time, by within 30 days, I have to make an application under section 17, subsection 4, before the adjudicating authority. Now, adjudicating authority, after receiving that application, will take recourse under section 8. Kindly come to section 8. Section 8, subsection 1. On receipt of a complaint under subsection 5 of section 5 or application under subsection 4 of section 17, this is relevant, or under subsection 10 or section 18, if the adjudicating authority has reasons to believe that any person has committed an offense under section 3 or is in possession of proceeds of crime, it may serve a notice of not less than 30 days on such person, calling upon him to indicate the source of his income. Kindly see, source of his income, earning or assets, out of which or by means of which he has acquired the property attached under subsection 1 of subsection 5, or seized or frozen under section 17 or 18, the evidence on which he relies and other relevant information and particulars, and to show cause why all or any of such properties should not be declared to be properties involved in money laundering and confiscated by the central government. Now, your lordship, kindly take 17(2). The adjudicating authority shall, after considering the reply, if any, to the notice issued under subsection 1, hearing the aggrieved person and the director or any other officer authorized by him in this behalf, and taking into account all relevant materials placed on record before him by an order, record a finding whether all or any of the properties referred to in the notice issued under subsection 1 are involved in money laundering. Then subsection 3, where the adjudicating authority decides under subsection 2 that any property is involved in money laundering, he shall, by an order in writing, confirm the attachment of the property under subsection 1 of section 5, or retention of property or record seized or frozen under section 17 or section 18, and record a finding to the effect whereupon such attachment or retention or freezing of the seized or frozen property or record shall continue during investigation for a period not exceeding 365 days, and or the pendency of the proceeding relating to any offense under the Act before a court or under the corresponding law of any other country before the competent court of criminal jurisprudence and outside India, as the case may be, and become final after an order of confiscation is passed under subsection 5 or subsection 7 of section 8.
Mr. Chakravarti, here in this case, provisional order of attachment has been passed.
That is in addition to the freezing. That is section 5. provisional attachment of property. My lord, section 8, subsection 1, your lordship will find at the top, section 8, subsection 1, that there can be application under section 5.5 or section 17.4. Both provisions are there before adjudicating authority. 17 is freezing or seizure, and section 5 is provisional attachment. Here, my lord, what they are challenging today before your lordship is a freezing order under section 17.1a. What I portray before your lordship, that section 17.1a is followed by application of section 17.4 before adjudicating authority. It is followed by retention order under section 20. It is followed by complete adjudication mechanism under section 8. Thereafter, the adjudication order is subject to appeal. My lord will kindly take
For the
section
tribunal.
24.
Yes, yes, I know that. I have seen it.
Section 24, tribunal appeal. Thereafter, section 42, high court appeal.
High Court.
A complete mechanism is provided. So, bypassing all these provision, my lord, section 8, your lordship has seen.
No, but Mr. Chakraborty, the notice is to be issued by the adjudicating authority upon the person who passes the order, or the deputy director or assistant director, whoever who passes the order of freezing, he communicating it to the adjudicating authority. But there is petitioner getting the opportunity to challenge it.
No, my lord, kindly come to section 8, subsection 1 once again.
Yes.
Section 8, subsection 1.
Yes, 8.1.
Yes.
This speaks about applications under section 17.4.
Thereafter, my lord.
They don't say that whether they have made that within 30
My lord,
days.
kindly, my learned senior will kindly allow me to complete. He will have his own turn again. My lord,
Sorry, Mr. Chakraborty, you continue.
Section 8, subsection 1. On
Yes.
receipt of a complaint under subsection 5 of section 5 or application under subsection 4 of section 17 or under subsection 10 of section 18, if the adjudicating authority has reasons to believe that any person has committed an offense under section 3 or is in possession of proceeds of crime, then my lord kindly mark, it may serve a notice of not less than 30 days on such person, calling upon him to indicate the source of his income, earning of assets, out of which or by means of which he has acquired the property.
Right, that I have understood. That means the adjudicating authority will issue a notice upon the person concerned whose property has been frozen.
And the last part is, and to show cause him.
Yes.
And to show cause. Why all or any
So
such
you-
property?
Here since the person whose property has been frozen is Prasanna Rai, therefore the notice has been issued to him.
Correct.
Not be issued to him.
Correct. Correct, my lord. Because it is Prasanna Rai and his wife who are the owners of these properties. This particular gentleman, the petitioner before your lordship, has no locus. He is showing a bipartite agreement, whereunder my learned senior has already indicated. He has entered into an agreement with laborers and for the purpose of only plucking and selling of green leaves. So how became he got the locus with respect to the properties?
Yes, Mr.
But,
A complete frivolous application, my lord, praying for dismissal.
Well, first he should prove his locus as to how he has a right to maintain this.
Come within this.
But I'll answer because they have summoned my client, but I get the locus. A one sentence answer to my learned. If I had no locus, they would not have summoned my client.
Summoned, so my lord, we will say.
My lord,
we can summon him
if
also
I am
as a
summoned, I
witness.
have a right to object.
Under section 50, under of the PMLA Act, he can be summoned as a witness.
So
in
I have a
order
locus to
understand that how
challenge
he-
my summoning.
My lord,
So
let my
you are
learned senior make his
questioning about
argument.
the locus.
He has
And
not
I am
questioned the
not a
summons.
person who is involved. Don't ask my client to appear and be harassed.
But then if you are, Mr. Mukherjee, you are only questioning the summoning, then how does the question of
But I'll just
freezing arise?
answer. I'll answer one by one after they're finished. Lord, it is a double barrel gun against me, Lord. Both of them are not arguing.
No, my lord, I apologize, my lord, because I am technologically challenged. Therefore, I am requesting I
Just pulling
render
his leg,
unqualified
Lord, it is-
apology to my lord and my learned senior friend, my lord. I am always used to appearing in court and arguing. This is a few occasions when I am being online. So therefore, my lord, Arijit is arguing. My
But
lord,
he-
my learned senior friend may continue.
But I'll answer your lordship, Lord, on 2 points. Lord, about the locus, which Mr. Trivedi has my lord, contended, and about my lord, a question that fell from your lordship to Mr. Chakraborty about whether my lord, there is a right of appeal or not, that did not elicit a direct answer to your lordship. Because my lord, this going to the adjudicating authority, my lord, as by now your lordship had understood my lord, the workflow. But this is all that I challenge is my lord, that the freezing. If the freezing has to be my lord, within 30 days by virtue of subsection 4 of section 17, it has to be placed before the adjudicating authority. I am my lord, also questioning whether that has been followed or not. If it is before the adjudicating authority, then my lord, the other processes will follow. My learned friends do not come before your lordship with a particular date or my lord, whether there has been a compliance of my lord, section 17(4) or not. But freezing is a temporary action, as your lordship has understood my lord, from the scheme of the statute. It has to be ratified by my lord, somebody more superior, entitled to inquire. The adjudicating authority comprises of my lord, a judicial officer and other persons. And after that, my lord, I have my lord, steps to my lord, see the veracity of that. So, my lord, as of today, my client, my lord, he was running the show, he was my lord, given the notice. Once, my lord, my lord, yes, my lord, that page 90, my lord, that was my lord, the order which is under challenge.
No, this is,
But that summoning order, that is in the other writ petition, item number 5. Item number 5. Item number 5, my lord, the order is a bit different, but my argument will be, my lord, on the legal point will be same.
yes, this I have seen.
That your lordship has seen. Now, my lord, on this, my lord, the powers under section 17, these have been dealt with by the Supreme Court. The Supreme Court in my lord, a 3 judges bench also dealt with my lord, the virus of my lord, the PMLA Act. I have
Let us
not
ascertain
challenged.
the stage because we'll not move anywhere till we get the full picture. Let
My lord.
Mr. Chakraborty produce that, Mr. Trivedi.
But first the attachment order and my lord, whether they have taken any steps in terms of my lord, 17.
My lord. My
Yes,
lord.
can you produce on the next stage the order of attachment and?
Lordship, we shall. We shall, my lord.
Produce it on the next so that I
Malad,
can
can
take a
this
holistic-
matter be taken up at principal bench with the consent of all the parties? Because
Yes,
all
my lord,
the records are
that
in
will last
Calcutta.
time also we prayed for that, my lord, because this
that
handicap
is beyond
otherwise.
my jurisdiction.
Malad, if all parties consent, it can be done.
No, that won't be proper. How soon can you come back with that?
Malad, the records are all in Calcutta. If they consent, because Mr. Mukherjee is also from Calcutta, Malad, it will be very easier for everyone to produce in
You
principle.
come and freeze my property here. Why can't you come with the documents here?
Very well, very well. If Mr. Mukherjee is willing to be at Jalpaiguri, I shall also be there.
No, Lord, I am only against the excuse of Mr. Chakraborty. Not that
No,
I am averse to
I have just tried to show the convenience of Mr. Mukherjee, Mr. Trivedi, and the authority also. I just tried to point out that.
Very well. लिखे नहीं Todd.
My lord, 9th, if it is permissible.
9th, I am here.
9th, my lord. If my lord permits us to come on 9th.
If not, Lord, I'll be trying to assist your lordship. Lord, 9th, I have some difficulty, but I'll try to assist your lordship online, Lord. But before that, let them, Lord, give me a copy of the attachment order and the 17(4) order.
My lord, perhaps that is not permissible in law. I will demonstrate. On 9th, I will again demonstrate before your lordship. With the authority of
But if they say that it is beyond law, Lord, to intimate a person whose property is being attached.
Yes, not his property. That's again the point. Not his property.
He is just entitled to plug leaves. That also at the best if he wants to.
Lord, they have omitted to see, Lord, the other agreement.
Certain machineries.
They should
In
see the other
respect of-
agreement also.
In respect of, whereby machinery is mentioned in this as mentioned in the said order, comma, pertaining to the aforesaid tea estate and bringing the tea estate to a screeching halt. Screeching, S-R-E-E-C-H-I-N-G, H-A-L-T, screeching halt. Mr. Mukherjee takes this quote through the provisions of section 17 and submits that the section 17(1)(a) and submits that the expression freeze within inverted comma should only be deemed to mean a clog on transfer or dealing with the property, with the subject property. Full stop. He submits that the expression within inverted comma or otherwise dealt with must be read ejusdem generi with ejusdem E-G-U-S-D-E-M-G-E-N-E-R-I-S, ejusdem generi with the preceding expression within inverted comma transferred. And as such, freezing could not mean restraining the properties, stroke machineries, machineries of the aforesaid tea estate from being operated upon or being functional. Full stop. Paragraph. Mr. Trivedi, learned senior advocate, learned deputy solicitor general, appearing for the Union of India for the respondent numbers 4, 5, and 6. Yagar order recorded DSGI 4, 5, 6. Submits that the writ petition itself is not maintainable in as much as the petitioner has no locus to move this court challenging the order of freezing. Full stop. Paragraph. He takes this court through the memorandum of settlement annexed at page 31 of the writ petition, annexed as annexure P2 to the writ petition and annexure P2 to the writ petition and submits that the petitioner was not given any proprietary right in respect of the machineries that have been frozen. Full stop. He submits that from the said agreement is between the petitioner and a workers' union, a labor's union, and as such the petitioner could not have claimed any semblance of right.
Litigation order or appeal order,
akin to that of ownership over the machineries that have been frozen. Full stop. Mr. Trivedi further submits that in any event, this writ petition should have deemed to have spent its force in as much as during pendency of the writ petition, comma, after the learned advocate for the petitioner had sought for time on June 18, 2025, comma, an order of attachment has been passed by the relevant authority. Full stop. Paragraph. Having heard the learned advocates appearing for the respective parties and having considered the material and report, it appears that before proceeding further, the present status must be brought to the notice of the court. Full stop. The respondent numbers 4, 5, and 6 shall produce before this court the steps taken by the order of attachment stated to have been passed in this matter during pendency of the writ petition. Full stop. list this matter for further consideration on July 9, 2025.
It may be fairly at the top.
Will be at the top.
It will be on the top.
So that we can have the return flight.
On 9.
9, my lord.
9th is Wednesday.
Wednesday, yes. So we'll have the return flight after getting leave from your lordship. Deeply obliged.
Much obliged, Lord. Agreed.
Deeply obliged. My lord, same order for item number 4 and 5.
4 and 5 covers it.
Same order.
My lord, I am appearing.
The memorandum is also the same memorandum.
No, Lord, there is some
Same.
not factual differences are there.
Same,
But
same.
in substance, it is same.
Same.
There are two officers who had been who had passed the freezing
No,
order.
but,
That
but the
text,
agreement, I have recorded the factum of the agreement. The agreement is the same there also.
Same. Agreement is same.
the agreement is same. But in
Agreement
respect of
is
a different tea garden,
একই করুন একসাথে করবেন না আলাদা আলাদা ওরকম
that's a different tea garden.
হ্যাঁ ওটা বামন
That
ডাঙ্গা
is,
টি এস্টেট
এটা হবে something, এটা something লিখবেন,
Yeah.
something, SAMSING.
Item number 5.
আছে লেখা আছে ওখান থেকে দেখে নেবেন
And in this case, Lord, I have also challenged the summons.
ভেরি গুড
Item
That
number
is-
5.
কারেক্টেড
The item number 5.
My lord, that challenge has become infructuous because someone he has cooperated, he has
Lord, I
complied
have,
with.
yes.
statement recorded.
That I agree.
Statement has
So
already
that
been.
challenge become infructuous today.
I'm just dictating a paragraph.
Yes.
Kindly, Lord, record that my client has responded to the summons.
Yes, I'm also saying he has complied with. So that
ওইটাতে
became
একটা
infructuous.
রেকর্ড করবেন যেখানে মিস মুখার্জি সাবমিশন রেকর্ড করছেন সেখানে আরেক জায়গায় রেকর্ড করবেন যে Mr. Mukherjee further submits that the summons issued to the petitioner are wholly illegal and as such the petitioner has sought quashing thereof. Full stop. Paragraph এখানে ওনার রিপ্লাই ওখানে লিখবেন Mr. Trivedi has further submitted that the challenge thrown to the summons has lost its force in as much as the petitioner has already responded to the summons and quashing thereof now will serve no purpose.
Lordship.
My lord, deeply obliged.
My lord.
Deeply obliged.
Lordship, I'm grateful.
When I was assisting Mr. Trivedi, DSG, and I was appearing along with Mr. Debshomo Boshak and Ms. Swati Singh.
You give the names in
Lordship, I'll give the names.
Mr. Singhania is there.
I am-
Mr. Singhania will assist with that minute.
Lordship.
Deeply obliged.
Grateful.
Taking your lordship's kind leave.
With my lord's leave.
Thank you.
Obliged. Obliged.
The petitioner, my lord. The petitioners have come up with a very innocuous prayers, my lord. At the outset, may I take lordships to page 23, my lord. Kindly see my prayers. But may I kindly be allowed to take a lordship to the prayers first, then I'll. The prayers are very innocuous. Yes, my lord. Now, my lord, the factual aspects of this matter are, my lord, the petitioner number 1 is the mother-in-law of the petitioner number 2 and mother of petitioner number 3. Lord, yes, my lord. My lord, the dispute is completely different. My lord, kindly appreciate, my lord. The respondent number 9 is also the son of the petitioner number 1, brother of the petitioner number 3, and brother-in-law of the petitioner number 2.
Lordship. Lordship, this is a totally civil dispute, Lordship.
No, not at all.
And
But I'll portray, my lord.
Lordship, first of all, this is a civil.
My lord, kindly appreciate, my lord, the facts. My lord, my lord, they are duty bound to, my lord, ensure the safety and security of my life and limb. My lord, that is. Yes, my lord.
She is the claiming that she is the wife, Lordship, and how it is possible for the police personnel. This is the report. Rani Kumar, the other was not done. That is a before Rani Kumar is the guy. Rani Kumar was the 5 years. And Lordship, this private respondent number 6 already lodged a complaint against this writ petitioner and the husband and the other in-laws, Lordship. This is a totally private.
Well, kindly appreciate, kindly bear. Well, kindly bear with me for a moment, my lord.
It says that on 7th of May 2025, one Vishnu Khan, number 2, came to the PS, submitted written complaint that
My lord, I'll take.
Number 317 of 2025 has been initiated. We took up the inbox to on ASI that she has taken up investigation. Out of 3 FIR name of which persons who were around made by the ACJ after completion of investigation, IU has submitted charge sheet in this case. So what?
My lord, kindly bear me for 5 minutes, my lord. My lord, kindly take up page 29, my lord. Only 5 minutes, my lord. I will take only 5 minutes. My lord, kindly take up page 29, my lord. The private respondent number 6, claiming to be the wife, lodged a petition under the Protection of Women Against Domestic Violence Act in before the Judicial Magistrate, Kamru. My lord, kindly comes to page 46, my lord. My lord, kindly see prayer B. Yes, my lord. Part 2. My lord, there she has claimed residence order. My lord, she is admittedly. Yes, my lord. Now kindly comes to page 162. My lord, kindly appreciate, my lord, she claiming that she is staying in her matrimonial home since 2022, lodges a DV Act case in.
Lordship, is this the matter of decided by the writ court, Lordship?
My lord,
Can
kindly.
writ court will.
Yes, my lord. Yes, my lord. My lord, now, my lord, kindly comes to page 162. Well, kindly ensure my safety and security.
Grateful.
Deeply aware.
Lordship, I am on behalf of the petitioner paying for not today, Lordship. Lordship, Learned Council is out of station due to some personal emergency, Lordship, kindly.
Lordship, 99 for the petition. Lordship, every evidence service, Lordship. Lordship, the matter is that the petitioner is a government contractor, registered contractor, Lordship. And he works under the various department, including the respondent number 2. That is the Pradhan of one Panchayat, Lordship. In course of his such capacity, Lordship, a tender has been floated with regards to the some work that has been come to the page number 19, annexed P2, Lordship, page 19, Lordship. And in there is a work, is a pipe, a sanitary pipe connection, and there is something over the area of the construction work, Lordship. And the petitioner has participated in the tender process, and he was chosen as a L1 bidder. And therefore, work order has been given, that has been page number 22, P3, Lordship. Lord, given. Now, Lordship, there is a condition of the tender, that is the entire work tenure is 45 days from the date of getting the work order. Lordship, and the work order has been given. Now, Lordship, there is work order has given 7 days after. Now come to the Lordship, kindly page number 20, 20, sorry, 20, Lordship, kindly page number, page number 32, page number 21, 32. Points number 32, page number 21. Points number 32. 2. After receiving the work order, contractor must keep in close contact with the Nirman Sahayak of this office to enable him to check the quality and quantity of the supplied materials from the time to time. That has been, after the work order has been given, he has to contact with the respondent number 8. And he made an meet with the respondent number 8. Whatever he collected the materials that should be examined by the 8, and he is not been supported by this respondent number 8 because of his dilatory tactics has been adopted by the respondent number 8, and therefore their time has been elapsed for 10 days, Lordship. However, he started the work with his better and greater experience, and Lordship, during such construction work is going on, Lordship, a setback has come to the face, he has to face that some local political person asks them to provide some money for due to such work. And that has been 1,80,000. And that is, and Lordship, I have been, matter has been intimated to the Pradhan and the respondent number 8 for the help because of he is the official authority. But in this meantime, they did not provide any help, and therefore I have to lodge a complaint that is in 24, page number 24, P5. This is the sworn police. In spite of that, I am trying to complete the work, and 70% work has been completed. In the meantime, Lordship, the respondent number 2 gave me a notice on the P4, that is 23, and cancel my work order. That is been 23, page number 3, 23, next P4, Lordship. Get it? And my work order has been cancelled, and I was diverted from complete the work. There, in the meantime, Lordship, I have been invested 8 lakhs. Because of 13 lakhs, there is total work order. 8 lakhs has already been, I have invested. I have completed the 70% work. But Lordship, this cancellation order given without giving me any show cause or any reasonable opportunity to given the why I have been terminated from the tender process. That has not been given. Abruptly, I have been cancelled the work order, Lordship. And therefore, Lordship, I have been given a representation before the authority, that is been page number 25, P6, that you have cancelled my work and I have not been given any amount which I have been given.
My lord, the panchayat is the answering respondent. But if your lordship kindly, I'm for the state, my lord. If your lordship kindly sees the tender, the work has to be completed within 45 days, my lord. Time is the essence, my lord. Yes, I'm coming to that, I'm coming to that. Now, my lord, if lordship kindly sees the work order, when it was given, page 22, 21st January 2025. Within 7 days, you have to commence the work. Now, my lord, the cancellation was done, termination was done on 13th May 2025. So, in between 4 months have elapsed. Yes, when did it make the complaint? On 20th May. That is after receiving the cancellation. It's an afterthought. Now, my lord, kindly sees the representation. On 11/4, page 26. On 11/4/2025 at about 12:30 p.m. at construction site of my client at Poschim Mohamari booth, some local hooligans started obstructing and vandalizing the pipeline. They destroying all the equipments, such and such. For that, yes, for that, the incident took place. My client could not started the work further. So work has not even started. Please, I'm not interrupted. Please.
No. You are continuing.
Not yet started. And nowhere they have stated that how much work they have completed, or they have made repeated representation that you please check the quality of the materials that have bought. No, nowhere. There is no document to that effect.
Lordship,
Now in this petition, they are saying all these things.
Lordship, Lordship, in the meantime, I was been many more times I visited to the office. I was prevented. Lordship, that has been their letter. That is, I have been completed 70% work. This is from their office. In the meantime, so it is not. Lordship, Panchayat, you are.
I'm for the state.
No, he is not. Our service has been completed. Lordship, in the meantime, they have been, if the work has been, Lordship, because of if in the meantime, the work has been done to the another person, I have been invested, say, Lordship. That's wrong.
Lordship. Development. Grateful, Lordship.
26.
Bring for not to the lodge. No, no, lodge. Grateful.
27.
27 for the state, my lord. Yesterday also they paid for time. This payer can be considered now. Family pension.
Upon the opposite party is completed. The matter pertains to disbursement of my pensionary benefit. The petition is superannuated in the year of 2018, but my pensionary benefit has not been given. I don't know. I've made a representation. Kindly, my representation may be considered, Lordship. It's page number 27. And it was received by the department. It was received on 26th of May 2025.
Shortage of service, my lord. 10 years is required. He has served for 9 years, 11 months. And 11 months and 14 days. There is a shortage, 16 days, there is shortage of 14 days. Minimum 10 years service is required, my lord.
Lordship, my representation may be considered and reply may be given in this regard.
As per the date come.
Lordship, let them answer through a affidavit or my representation may be.
28, I am for the petition. Income tax matter, my lord, very small issue involved. I am challenging here, show cause notice 143 or my lord, income tax generally appears Mr. Singhania and learned Deputy Solicitor General, my lord. I have served, my lord, this is affidavit of service on 24th. No, my lord, today I am returning, my lord, that is but in that case, my lord, lordship may subject to correction, my lord. Lordship may hear me. This is a small issue involved that. Oh, yes, yes. No, 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 order not required. If your lordship subject to correction, my lord, my submission may be recorded, then next week any date. Because I have to refer my lord some judgment and also. Then no, yes, yes. Learned advocate and my lord, in that case, password I am waiting for some time. To phone for me. Yeah. Fine.
Madam, for the petitioner lordship. Well, it's a kind of mercy petition
But
lordship.
I'm for the distribution company.
Yes.
Well, I'm for the distribution company limited.
Malad, the petitioner, Malad, is a senior citizen, Malad, a lady. A marriage between the petitioner and the private respondent took place 47 years back. Yes, Malad, I am just. No, my lord, it has passed. My lord, I have.
My lord, may I submit something?
My lord, I have annexed. Yes, page 20. Yes, I have annexed, but that is not the certified copy of the order. Page 20 onwards of my petition, lordship. This is the order. It's
20.
My lord, yes, my lord, it's a order of in the year 2002, lordship. My lord, this much, my lord, this copy only I have in my hand. Lordship kindly comes to page 22 is the, my lord, operating part. My lord, I am reading it, lordship. It will be easier for your lordship. হ্যাঁ মোকদ্দমা 22 এই মোকদ্দমা একতরফা শুনানির পর অংশত মঞ্জুর করা হলো, তবে বিনা খরচায় প্রার্থিনীকে প্রতি মাসে ভরণ পোষণ বাবদ 600 টাকা, 3 কন্যা ও 1 পুত্রের জন্য প্রতি মাসে ভরণ পোষণ বাবদ 600 টাকা করে 2400 টাকা সর্বমোট।
Yes,
No, my lord, yes, lordship, but the thing is, my lord, the petitioner was getting the money, my lord, with the cooperations of the employer of the respondent number 6. But suddenly, lordship, that has been stopped, and it has come to the knowledge of the petitioner that the respondent number 6 has been, my lord, retired from his service. Now, my lord, he made representative.
My lord, we are not the answering respondent. We are not the answering respondent. We are the state respondent, my lord. Second, my lord, the
I'm for the
execution, they have
I'm
to
for the
go before
distribution
the
company.
execution court.
Well, I'm for the distribution company. Now, my lord, this is a feat case, my lord. For my lord, referring the matter for my lord civil court, because my lord, this person, the respondent number 6, our group D employee who already retired, this maintenance order was passed in the year 2002. Now, my lord, now in our record, my lord, this particular employee, my lord, nominated one Parvati Singh as his wife. So his pension paper, my lord, was prepared accordingly. Now this lady, my lord, is claiming to be the wife, and my lord, lordship knows that there are caten of judgment, my lord. Any order passed under section 125, my lord, need not, my lord, no strict proof of marriage is required. It can be decided only by a civil court. So, my lord, my full submission, the matter may be directed, my lord, the petitioner may be directed, my lord, to get an order, my lord, to end this dispute. Who is the wife? From when she was married? On what basis, my lord, the name of Parvati Singh has been nominated by the respondent number 6? Now, respondent number 6 is not approaching. He could have, my lord, disclosed document regarding, my lord, his nomination. What is the status of this petitioner? My lord, everything. Sorry, my lord, I'm not audible.
you bring that nomination on record by way
Yes,
of.
my lord.
a
Let me, then,
report.
my lord, let me file, my lord, a short report, my lord. In
Because
disclosing all,
unless that document is there on record on the basis of oral submission, I
definitely,
will not be able to.
definitely, my
make
lord,
that.
definitely, my lord. Then, my lord, kindly give me 2 weeks time, my lord, for filing a report, my lord, in the form of
Why, she
affidavit.
is a lady, senior citizen. Why 2 weeks? Only one document on record. File it within 1 week.
My lord, I have to arrange it from here, my lord. This is all records, my lord. In fact, my lord, he before retirement, my lord, he was working, my lord, several places. So, my lord, and my lord, from 2014, my lord, till 2025, my lord, she had not made any representation, my lord, to the authority. For last 10 years, my lord, she remained silent. I do not know, my lord, what is the reason behind, my lord. Writ petitioner could have explained, my lord, the last representation, my lord.
Yes, madam. Why all these days you were silent? Suddenly, what has happened?
My lord, he made representations. Lordship kindly comes to page 26. It's the earlier representations. Before that, Lordship kindly comes to page 24. This is another representation.
That is
Now,
not dated, my lord. That is not dated.
Not dated, yes,
Not
yes.
dated.
Pa-
And my lord,
page,
it
page
is
23, page 23, your lordship will get that has been received by the divisional manager, my lord, Dokhin Dinaj.
26, page 26 is, has a postal receipt of October 2024.
page 26, my lord, we are acknowledging. But
Lordship
that is,
kindly comes to page 23. There is the hand received, Lordship, by the by the divisional manager Dokhin Dinajpur, where from the private respondent number 6 has been
that is, my lord,
inscribed.
dated 12th March 2004.
Yes.
This is long
Now,
back,
Lordship,
20 years.
at the very outset, I have submitted before your Lordship. This is a kind of mercy petition, Lordship. A aged
No, my
lady,
lord,
only
we are not here, my
3,000
lord, to
rupees.
show mercy,
And
my
my
lord.
lord,
In that
I
event, my
have
lord, we
no,
have to deprive, my lord, some other person. So, my lord, we
since
have to
the
go by our records.
my lord, since Lordship kindly comes to the last communications of the my lord, the office, page 31.
Yes, I've seen that. They want
They are
certified
asking
copy of
the
the order.
certified copy of the order.
Why don't you provide that?
My lord, that is not there, my lord, in the
Why?
with the petition. My lord,
You can get
2002
it.
order. My lord,
Certificate copy will be,
it's not
records will be there in the court.
It's not been able. My lord, I am trying. Let them file the report. My lord, I am in the meantime, I am trying to get the certified copy. But my lord, my instruction is they are
My lord,
not
twice
able
they
to
were
get the
communicated,
certified copy.
twice he was communicated, madam, but no reply, my lord,
Petitioner.
was received by us.
The petitioner is aggrieved by nonchalance, CHALANCE, of the respondent, West Bengal State Electricity Distribution Company Limited, towards the petitioner, in as much as the said respondent has not been deducting has not been making payment of monthly maintenance to the petitioner upon deducting an equivalent sum from the amounts payable to the respondent number 6 by the respondent, WB West Bengal State WBACDCL bracket hereafter WBACDCL by the respondent WBACDCL, full stop. The petitioner says that petitioner submits that there is an order passed by the learned
Judicial
Where is the order?
magistrate at Mathang.
But judicial magistrate, my lord,
learned judicial
Malavanga.
learned judicial magistrate at Mathabhanga, Kuch Bihar. Order dated করে দিন, order dated February
7th of
2,
May, 2002.
February 2, 2002. February 7, 2002.
Not me, Lordship.
But your prayer shows 2,
My lord,
page 18.
Then it will be.
Acha, May 7, 2002. May 7, 2002. In Miss case number 8 of 2001. By which the respondent number 6 had been directed to pay maintenance to the petitioner, and that the petitioner had been getting such amounts through WBACDCL upon the same being deducted from the petitioner's salary, from the respondent number 6's salary, same being deducted from the salary of the respondent number 6. Full stop.
My lord, pension, my lord, he has already retired.
Nah, that is her case.
Yes, 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 yes.
Paragraph. The respondent number 6 has since retired. Full stop. The petitioner submits that the petitioner is still entitled to the said amount to the maintenance in terms of the aforesaid order dated May 7, 2002. And such sum should be paid to the petitioner by deducting the same from the pension paid by the WBACDCL to the respondent number 6. Full stop. Paragraph. Mr. Chattopadhyay, learned advocate appearing for WBACDCL submits that the learned advocate appearing for the petitioner invites the attention of this court to a letter dated May 2, 2025, issued by the manager within bracket F&A CORP Corp dot pension cell, WBACDCL, whereby the petitioner has been required to submit a certified copy of the order dated May 7, 2002 and the current status of the said proceeding in order to enable the WBACDCL authorities to proceed further. Full stop. Paragraph. Mr. Chattopadhyay, learned advocate appearing for the respondent WBACDCL submits that the respondent number 6, who is a retired employee of the WBACDCL, has nominated another person as his wife in the records of the WBACDCL, and as such, it is at this stage not possible for WBACDCL to deduct any sum from at this stage it is at this stage it is not possible for WBACDCL to deduct any sum from the pension payable to the respondent number 6 and pay the same to the petitioner, till such time it is decided as to who is the wife of the respondent number 6. Full stop. He submits that this matter ought to be decided by a competent civil court. Full stop. Paragraph. Having heard the learned advocates appearing for the respective parties and having considered the material on record, this court is of the view that WBACDCL, who is the authority?
5.
The respondent number 5, divisional manager. Respondent number 5 should file a report in the form of an affidavit disclosing the nomination done by the respondent number 6 as submitted by Mr. Chattopadhyay. Full stop. Such report must be filed before this court within a period of 2 weeks from date. Full stop.
I want to file an exception to the report.
The petitioner shall be at liberty to use exception thereto within a week thereafter. Full stop. যেখানে লিখেছেন shall be filed within 2 weeks from date. আছে না? সেখানে with prior service of a copy thereof upon the learned advocate for the petitioner. Of a copy thereof upon the learned advocate for the petitioner. Full stop. Paragraph. the petitioner shall be at liberty to take exception to such report within a week thereafter, full stop. List this matter for further consideration before the next circuit bench, available immediately after expiry of the period fixed for filing of the report and taking exception thereto.
My lord, subject to correction, lordship. My lord, the divisional manager, my lord, the Balurghat, my lord, will he be able to file the report, or my lord, the Bidut Bhavan, my lord, my learned
Who
friend?
will file the report, Mr. Chattopadhyay? Who will file the report? Mr. Chattopadhyay, who will file the report?
My lord, Lordship kindly indicate that divisional manager or any competent person. Because my lord, I do not know my lord, who is going there.
Divisional manager যেখানে আছে না, ওখানে লিখে দিন the competent authority of WBSCDCL.
Yes. Yes.
Grateful, Lord.
Grateful. Yes, affidavit of service filed to debit.
Before my lord rises, my lord, before my lord rises, may I be allowed to mention one matter? The urgency is that a victim has been raped and his video has been circulated. We have went to the police stations. Police people are sitting tight. They are making us run from pillar to post, stating that we do not have the jurisdiction. Go to cyber cell. Cyber cell says we do not have the jurisdiction for rape.
My lord, one humble indulgence, lordship.
Yes.
I know, my lord, this is not the time to mention, but one humble indulgence. Today, one matter was fixed for coming on this before this bench. The order was passed as it will come under the motion hearing heading on 4th today itself. But my lord, the matter has not come. So if your lordship is kind enough to put the matter in the hearing list any day that your lordship suits.
Very well, you give it's a hearing matter.
Yes, my lord, but it is
Hearing
all
matter,
all completed. It is all completed. Only written notes of argument has to be submitted. Nothing else.
Mr. Bhattacharya, hearing matter, I have said that I'll take mentioning next week. So you mention
My
it
lord,
on
let the matter come in the next week. I will just give the order, copy of the order and the mention slip. Let
Very
it come in the next week. I am so grateful to my lord. I'll presently instruct my learned junior to go and do the needful. I am so grateful.
Very well.
Grateful, my lord.
চলো দুটো বেজে গেছে তো অল্প হ্যাঁ হ্যাঁ 3.5 রেজলিউশন আছে তো হ্যাঁ সেটা তো এখন নেই রেজলিউশন 3.5 থেকেই থাকার তো কথা দেখি ম্যাটারটা দিন দেখি দেখা যাক But you are there. Yes, yes. এটা পাস ওভার করে রাখো দেখা যাক has not been given. What has happened? Nobody is appearing. No, no. There is a resolution at 3:30, not now. No. There is a resolution of 3:30. That I know. Where? Who has taken? No, no. I have the resolution of the principal bench. It is only 3:30 rising. There. Not to pass adverse order. Very well. Pass over করে দিন একটু। Pass over. Petitioner is there. Very well, yes. Why are you not releasing the pension?
We have tried, now Rocky kindly comes that they are prosecution, Rocky is based from the last 19. They are the legal years of the thesis sector. In the short term, one more. It's not because of lawsuit, so we don't know. After the date of the first one, the marriage. Yeah. And now, they are the sample doctors of the earlier marriage and the present marriage. And the mother is there. Now, the last line of this memo that is written, and it's entitled the set of pensionary and death benefits among the legal heirs shall be followed as per the DCRB rule 1979 as well. Now, the DCRB rule matter section 101(1)(b) has stated logically comes to paragraph 105. Pension paid to one member of the family. Substitute to the profit constitute the note under Rule 104. The pension awarded under the scheme shall not be paid more than one member of the government servant's family. At the same time, it shall be first be admissible to the widower, then to the minor children, and thereafter to mother, and lastly to the father. In the event of remarriage or death of the widower, the pension shall be granted to the minor children their natural birth. So, the widow will get the pension, the minor children will get the pension. If there is a marriage earlier, the minor children of that marriage will get the pension, and thereafter the mother or the father will get the pension. The lordship of the petitioner is entitled to get a share of the pension, family pension.
No, but is this a case of remarriage or it is a case of double marriage? Remarriage is
The first death certificate of the employee, page 14 is the joint report, page 15 is the approval of the appointment, thereafter lordship kindly comes.
16.
Yes, your lord. The first wife, she died of 28 January
2016.
Yes. Now, thereafter the marriage between the present petitioner and the employer. That is on
13th May 2016.
13th of June 2016. After the death of the first one.
May.
So it is not a case of that there are two wives that
You file a report. You file a report. Let them come with a report. That kind of an order.
And that
So that I have not taken that as a ground. They will now come up with the report. Not today. Not today. Your other side. Not today. Not. State. देखिए not today. Any.
From item number 35 to 42, item number 45 and 43, all are my lord, team and
Let us go one by one. That's better. One order is passed, that will govern all.
Yes, sir. They said it's my lord, activity. What order has to be issued in favor of the petitioner? That was regarding after COVID-19, my lord, it needs to know that there was a work order that we issued to reconstruct it for the schools, primary schools, after the COVID-19. My lord, what has been done? There are, my lord, the completion certificate all has been issued. My lord, this court that my lord, previously a writ petition was filed on a same cause of action by some other contractor within the same district, my lord. My lord, a coordinate bench of this court by Justice Bishwajit Basu, he heard the matter and disposed of by give a direction upon the DM, and a report was also filed by the BDO that there are insufficient fund and the DM is sitting tight over the matter. And my lord, Justice Biswajit Basu passed an order in this regard. A time limitation has been given, 6 weeks or 8 weeks, something was that. I can hand over the report to disburse the fund in favor of BDO, and thereafter BDO will disburse the fund in favor of the petitioner. So this is the report, my lord, and that was the report, and that was the order. I believe the report in this matter also is here, I believe.
I'd like to submit the report, lordship. Already we have sent the matter to the concerned authority regarding the fund, lordship, because we have some fund issues. কিছু দিচ্ছিস হ্যাঁ হ্যাঁ নিশ্চয় তো কোনো কিছু ই করছে না কারণ আগের অর্ডারটা আছে
এক্ষুনি দিলাম
দেখ
দাঁড়ান।
অর্ডারটা আছে শান্ত
আমি দেখছি আজকে দাঁড়ান 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 একটাই আছে দাঁড়াও
Here also they should file a report then in the form of an affidavit.
a lot of report
Or
is
if
there.
This is an
the report
instruction.
from yes
The report should be in the form of an affidavit so that I may act on that. On the basis of instruction directing them to give money is.
My
will
lord,
be a
that was the direction of Justice Shubhra Ghosh to file a report in the form of affidavit.
No,
Probably on
that action is-
or to file a report.
Well, on the earlier occasion.
Call for a
both are asked us to take instruction.
so this is our
We are ready with the
instruction.
instruction, my lord. But there was no direction to file a report in the form of affidavit. If my lord directs, we can file it, man.
You file it. How soon can you file it?
My lord,
1 week তো লাগবে এতগুলো আছে
minimum 1 week, my lord, because there are a bunch of. My lord,
It
2
will be the
weeks, my
same
lord.
thing.
Yes, my lord, but bunch of, my lord.
So
annexers also
same
will be
thing will be typed and it will be xeroxed. What was it?
no councils are different sir.
Councils are different, my lord, that's why.
But
State councils are different, my lord, that's why 2 weeks, my lord, minimum 2 weeks, my lord, kindly.
Not long
And let
pending
it
money.
be, let's settle in the next 30 days, because if it is 1 week
My lord.
also, we cannot.
মানে annexer গুলো
My lord, one submission, my lord, as there is instruction upon the council of the state, I think this is also
We are
sufficient.
ready to the instruction, but
Yes,
it
yes,
is in
yes.
form of affidavit, and court cannot file for.
This is also true.
এটাকে allow
Next.
তোমার কত নম্বর হবে? I beg to appeal for the state lordship.
Lordship, I represent the petitioner in this matter. A very innocuous prayer. Firstly, my affidavit of service. The petitioner is the owner of a piece and parcel of land measuring 4.79 acres. Now, over that piece and parcel of land, he has constructed a 3-story building in the year 2007. It is a residential commercial building. Now, in the year of 2014, he has entered into a lease agreement with one Geo company, Reliance Geo company, for installation of
Wi-Fi operators. Wi-Fi operators.
Wi-Fi operators. During that period, from 2014 till now, there were no obstructions. It has been running smoothly. The operators and their servicemen were continuously carrying out with their works. But lately, it has been observed that the private respondents, they have been obstructing the operators of the concerned Geo company to carry on with their works. Against that, a mass petition had been filed, which was considered by the concerned SDO of Jalpaiguri. The SDO forwarded the matter to the DPRDO. There, the DPRDO found out that there is no such thing called tower upon the land. I mean, landed premises. So I have come back before since they are creating nuisance and trying to dispose me from my peaceful possession of the property, I have been bound to look forward the matter before the SDO and made a representation before the concerned SDO as well as the police authority. Though it is a private matter, but when the private matter involves nuisance and it creates more escalation of the concerned dispute, then writ matters can be involved and entertained. My only prayer before your lordship is
Civil
my
court. Your remedy is before a competent civil court. You go
lordship,
and
my
get an
only
order of
prayer is
injunction.
when the matter is pending before the SDO, the matter may kindly be considered. I have one small and innocuous
SDO
prayer
also
that
does not have jurisdiction here. It is a pure matter where civil court competent jurisdiction can decide whether there is a dispute as regards your property, possession,
since the matter
egress, ingress.
lordship, since the matter is already pending before the SDO, that
Where
my
is that SDO's letter?
letter
That you have
is,
forwarded?
page number 41. Page number 41.
Page 41 is a
Representation.
No, you said SDO forwarded your complaint and all.
Yes,
Yeah,
no,
page
no, no,
41.
Not complaint at all. Private is no complaint.
It is the private respondents who had all complained against me. It is at page.
So if you are being obstructed in enjoying your.
Now, the biggest
your
problem I am
property-
facing, lordship, in this matter, between the dispute between the private respondents, is that the lease agreement between the Geo company and me, I am being served a notice whereby they are claiming damages
civil court,
against me.
civil court.
Lordship.
Civil court. लिखे नहीं. The
Sorry.
Other appropriate
Nine, na?
way law to seek other remedies available to the writ petitioner in accordance. Yes. Needless to mention that the police authorities shall remain obliged to maintain a strict vigil at the locale and to ensure that life and property of the petitioners as well as the respondents remain protected.
Lordship, one indulgence in respect of the both the parties.
I said
Lordship,
petitioners
Lordship.
and respondents means what?
Lordship.
Item 28.
Lordships, in item number 20, and for the revenue authority, order is applicable, your lordship, statutory remedies.
28.
Available, lordships. Income tax matter, challenge order passed under section 143, which is applicable order. So statutory remedies is
Assessment order.
lordships.
Yes.
So your lordships say,
I am
read,
discussing
there is an
assessment order.
Only,
jurisdiction.
only a small submission, only 2 minute submission. But here I am challenging the 143.3 order, read with 144 capital B, and also 2 penalty. The only short point, the show cause notice, my lord, only 5 working days given, and our statute says,
Lordship in work.
and my lord,
Income tax portal functioning 365 days, 24 hours.
You take it up in appeal.
my lord,
Otherwise,
subject to 2 minute submission, only 2 minute submission, subject to. My lord. In show cause notice, my lord, kindly have a
The
look.
order passed.
Yes, my lord. Order passed, my lord, on 26/11/2020. I am, my lord, driver in the police, West Bengal police, class 8 pass, my lord. I am not technology savvy, my lord. That
I
order passed.
understand, but there is an appealable, this is an appealable order.
Yes, yes.
The-
And only, my lord,
Lordship,
only my
writ
respectful
petitioner
submission
respect
is
the
that.
portal, participate in the portal and engage the
Penalty
advocates
order has
also.
also been passed.
My lord.
Penalty order has also been
Penalty, 2 penalty order pass. Only my here respectful submission is that show cause notice
See,
issued.
Mr. Rai, you also know,
Yes, yes, my
for
lord.
assessment orders, court is loath.
Yes,
We-
but my duty to communicate, submit here.
2022 order in
22 and
2025.
that, my lord, means that they not technology savvy, my lord.
And
My lord, SOP, my lord, section 144 capital B, that starting with non-obstinate clause, that whatever written, but 144 capital B has to be followed. Then subsection 6, Roman clause 6 comes. Says, show cause notice, but no time limit mentioned. But sub clause 11, it is mentioned the department shall follow the standard procedure. That SOP dated 3rd August 2022, which is relevant page annexed with my writ petition. Also, I am carrying the full set of SOP that says, my lord, that 7 days minimum. And our coordinate bench, 2 judgment I am relying, and also our Chief Justice bench I am carrying, division bench judgment I am carrying, that Saturday, Sunday also excluded. Saturday, Sunday will not count. That our division bench, in case.
assessment order was challenged there.
Yes, yes, yes. Assessment order challenge. That is why, my lord. My lord, 2 judgment, my lord, one Silekha Banerjee. দিচ্ছি আমি এটা Silekha Banerjee. Para 7, 8, 9, my lord. This coordinate bench judgment, my lord. Honorable Justice Raja Basu Chaudhary, my lord. তুমি SOP relied, my lord. 7, 8, 9.
What is the case here?
And here, my lord, show cause notice issued, my lord, page 60, my lord. Kindly have a look, page 60, my lord. The issuance time, digital signature, that 3rd November 2022, issuance 13:10:46 hours. So 3rd excluded, then my lord,
Yes.
3rd excluded, digital signature at page 63, my lord, 13:10 hours. So 3rd day is excluded, and my lord, page 63, middle portion, my lord, kindly submit response by 18 hours 10. So 10 exclude. So my lord, 5 working days given, that is 5th is Saturday, 6th is Sunday. And our division bench judgment, my lord, in the case of, my lord, Indu Goenka, that stated that Saturday, Sunday, my lord, counted, my lord, here. May I, my lord? Paragraph, my lord, 3(5). And here, my lord, state also SOP, my lord, that SOP.
Mr. Rai, there is a problem.
And
In all these cases, you had approached within the time.
yes, yes. And another case, my lord, division bench, my lord, in Green Valley, my lord, is also
Here you
important.
have approached after 3 years.
Yes, my lord. That is, my lord, I admit, my lord, because I am 8 past qualified driver, my lord, in the police service, and I miss all. I am not technology savvy, my lord, and I am not properly guided, my lord. Here, my lord, para 3, my lord, that Saturday, Sunday, my lord, excluded. My lord. And date of issuance and date of reply excluded.
All these assessment orders are within time.
My lord?
These assessment orders are challenged within time.
Yes, 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 yes. Yes. My duty, my lord, is to all as a officers of the court to submit fairly in all issues before your loss. And I explained, my lord, that I para 37, my lord, that I am 8 past qualified, and this all that issue, my lord. Para 37 on the repetition.
Show me the SOP.
Yes, my lord. This is the SOP. SOP, my lord. I have attached SOP, the relevant page 116, my lord. Attached with the writ petition, my lord. Relevant page. And I am carrying, my lord, full set. May I submit the full set?
Not required.
Yes, page 116, my lord.
Yes.
116, my lord, of the writ petition. This is the relevant page 1 and 13 I have attached, my lord, but also carrying full set, my lord.
And which is the section you are referring to?
Yes, my lord. Yes, that section, my lord. Section 144 capital B, my lord.
Tax Act. Income Tax Act.
I'm giving my book, my lord.
নেই, মোটা হবে, পাতলা number.
আমি দিচ্ছি। 144 capital B. I'm pencil mark, my lord. Subsection 1, 6. বই আনো 6 request personal 7 Roman 7 10 11 এখানে শুরু হচ্ছে may I read one line first, my lord? My lord, here notwithstanding anything content to the contrary content in other solution of the assessment, reassessment, computation 143.3, 144, 147 has to be followed the following manner. So it is shall, my lord. Now, my lord, subsection 6 and subclause 7 and subclause 11, my lord. I have marked, my lord, with tact. দেখো তো বই জানতে পারো। Subsection 6, subclause Roman 6 says about the show cause notice, and 11 says that SOP has to be followed, my lord.
Subclause 6, then?
Then, my lord, subclause 11, Roman 11, my lord. I've marked also pencil. Next page, my lord. এটা কত সালের বই? কত সালের বই এটা? 22-23, হ্যাঁ থাকবে।
What about your delay?
Yes, my lord. Only, my lord, that reason is, my lord, this actual reason, my lord, that I trusted on a tax consultant because return submitted. I am residing in the village area. Jalpaiguri. Some village area, and I am 8 bus driver, my lord. My duty is on the police department, and I missed, my lord. I am not really technology savvy. I am only using my normal phone, my lord. This is only reason, my lord. No other reason. Para 37, I have stated, I miss all this, my lord. Otherwise, my lord, I have good merit in my case also.
No, but why did you come late before the writ court?
And that is was not known, my lord. That
Assessment order was of 2022.
yes, my lord. They have the letter issued, my lord, notice at page number 112, my lord. Thereafter, notice issued, my lord. Reminder notice, my lord. Page 114 in the month of January, my lord. But all these, my lord, uploaded in the portal. That is the problem. Not served in by the local officer, my lord, Jalpaiguri ITO, income tax officer, not by post. Thereafter, one day telephone, my lord. They telephoned and thereafter file return.
Where is all that written? Telephone you got where?
No, my lord, that is not written because that is unofficial. I have no proof, my lord. I have no proof, my lord.
It have made an environment. Will I condone this delay of 3 years?
Yes, my lord. That is my lord.
3 years delay, how will I condone? Sitting in
Lord-
jurisdiction.
Yes, my lord.
Lordships, he may prefer the appeal and the appellate authority in accordance with law decided he demonstrate the difficulties. If the appellate authority is satisfied, he has the power to condone the delay. But your lordship, once the order is appealable order, your lordships. At the, so far, my instruction, your lordship, SOP and others will be already followed, your lordship, day to day. If your lordships permit me by the 2 or 3 days time, I demonstrate the list of dates, your lordships. Show cause notice 3/11/2022, given the 7 days time, 11/11/2022. Now my learned sages cited the decision in 2024. But the show cause notice issued in 2022, given the 7 days time, your lordships. All the process, even if personal hearing, all the digital platform, income tax regime
Very
says
well,
faceless hearing.
Let him come after 3 days. He wants 3 days.
If your lordship, but if your lordship says date wise, show cause notice, 7 days complies in 11/11. And the digital platform, the writ petitioner submit his one response, in others 13/10/2022. That means the writ petitioners very well equipped in the digital portal. He engaged the lawyers also.
Very well, you come back after 3 days with your list of dates.
List of dates, your lordships.
List of dates, my lord, correction, list of dates are available in my writ petition.
No, his list of dates.
But my lord, regarding the,
Maintenance point kept open.
Yes, I'm not passing any order expecting adjournment.
regarding the show cause notice, my respectful submission is the legal provision and judgment and SOP, my lord.
Yes, I'll consider.
In
that.
this
You give me that
situation,
SOP.
only one.
Yes, my lord, I am giving, my lord, it is full set of SOP.
Lordship, only 1 point, Saturday, Sunday, 7 days notice, Saturday, Sunday in the meantime, but
No, if
digital
division
pay,
bench
there
says-
was nothing mandatory, just Saturday, Sunday excluded.
If division bench says it should
In 2024, your lordships,
Yes, my lord, division bench says, my lord, in
2024,
in case of Hindu Goenka.
lordship 2024, and this case is 2022.
No, that is not the related.
2022, all the proceedings 2022. He raised the question Saturday, Sunday is 2024, Honorable Court passed the order. But in 2022, your lordship, there was no judgment, no order of the Honorable Court.
That way you will not be able to interpret the law.
And my lord, I am also another judgment, my lord, I am giving learned other pen also. Monica Jaiswal, coordinate bench.
Hard learned advocates appearing for the parties, full stop.
Otherwise, my lord, I am leaving to your lordship for appropriate order. This is the situation, my lord.
No, very well. Let us see what. My affidavit of service data record.
No virtual. No virtual. No. My lord, he is my neighbor.
Yes,
I
yes, I
say
know.
throughout the year I am staying. Why he cannot stay? He will do virtually.
Because
Because
he's better off there. He's minting money.
Yes. No, first is duty my to assist lordship. My lord.
No. That is incidental. First is this.
No. Definitely not. I am grateful.
Learned, my lord, learned advocate appear virtually.
Nobody is appearing.
My lord, for the
No, for the petitioner, he says somebody is appearing virtually. I don't find anybody. Not today. How long will we wait?
My lord, 48 is the same.
48 call for
48.
Same.
48 is also same.
not today.
Same issue.
Not today. It can be finished in one day or
Yes, yes. But it is listening to the, already similar orders there. When it's a private dispute, there is the planning of the vehicle.
no.
49.
I'm for the state. Yesterday, someone appeared virtually.
Not today. There is a resolution today, they say not to pass. You are there.
49, He's appearing.
49.
Lordship, in item number 49, I am being led by Mr. Shahid E. Huda, who is appearing online from Kolkata. And yesterday we were directed to produce the judgment before your Lordship. So today we are ready along with the affidavit of service. Would be very grateful.
Where is Mr. Huda?
Lordship, Mr. Huda is appearing online.
He is not there. His name is showing, but he is not.
আচ্ছা দেখাচ্ছে তো এটা এই হুদাকে ফোন করে
What's the issue here?
Lordship, it's a Group 8 writ petition application regarding to some ration card issue, the issuing of the license of a ration dealer case, where some numerical problems are here. Would be very grateful if my lord kindly.
Lordship, I appear for the petitioner, my lord, that this Lordship had taken up yesterday, my lord. However, my lord, since my lord, the usual order was not available, my lord, Lordship had kept it today.
देखिए order को देखिए.
Lordship, may I place this order along with the affidavit of service?
Just one request, my lord, if your Lordship sees the order, my lord, the word that has been used, my lord, is my lord, detailed report in the form of affidavit, my lord. So, and there's a reason behind that, my lord. So I'll be praying for, my lord, the same order, my lord, detailed report.
Comprehensive.
Comprehensive.
You have seen this order?
Unless I go through the order, I cannot.
You don't have a copy?
Lordship, would be grateful if you kindly permit me to serve the copy after this matter gets over. I am having it over the phone. I'll show.
You will have to file a report, that's all.
That is it, my lord. That is it, my lord. In at least, my lord, 50-60 matters, my lord, same order has been passed.
What is the matter, Mr. Huda?
Yes, your lordship. My lord, the petitioner, my lord, is an FPS dealer, my lord. FPS, my lord, stands for Fair Price Shop, my lord. So, my lord, he's an existing dealer and he's catering, my lord, within his jurisdiction, my lord. My lord, in the meantime, my lord, in the same area that I cater to, my lord, a new vacancy notice has been published. Now, my lord, in terms of this new notification, my lord, a new dealer would be appointed, and once he is appointed, my lord, my cards would be curtailed. So I have challenged this vacancy notification, my lord, on various
In
grounds.
such regard, report has been called.
Yes. Because there is specific guideline that they need to follow, one of which is, my lord, the distance between, my lord, the two FPSs, my lord. And here, my lord, the central location is quite near the godown which I am, my lord, from which I am operating as of now. Yes, sir.
The petitioner seeks issuance of a writ of mandamus commanding the respondents to withdraw and or rescind and or cancel the orders dated February 11, 2022 and March 28, 2023, uh, issued by the Food and Supplies Department, comma, Directorate of Distribution, full stop. Directorate of Distribution, comma, Procurement and Supply, full stop. Procurement and Supply, full stop. The petitioner claims to be a fair price shop dealer in Shahapara, comma, Podamati, Mayanaguri, plot number 4. Bus, no, plot number 4, the Mayanaguri, full stop. Having FPS number 1328011000035. Petitioner number 1 Ligben is a fair price shop dealer in Shahapara. And the petitioner number 2 claims to be a fair price shop dealer in village and post Jalpaiguri Bazar, PS Mayanaguri, having FPS number WB 03288172112. Full stop. Paragraph. The petitioner submits that upon the promulgation of the Duare Ration scheme by the state of West Bengal, the petitioners have also been delivering relevant articles at the doorsteps to the beneficiaries thereof. Full stop. Paragraph. It is submitted by the petitioners that the what is the full form of SCF and S? The subdivisional controller, Food and Supplies, has advertised a vacancy for appointment of a dealer in central location Jalpaiguri Bazar Road, VDA memo number 290/SCFS/JPG/25 dated May 21, 2025. In respect of the same area where the petitioners have their FPS shops, fair price shops, FPS na kore, fair price shops. Full stop. The petitioners submit that if such vacancy is filled by a newly appointed FPS fair price shop dealer, then the petitioners' business interests would be hampered. Full stop. It is therefore that the petitioners have approached this court by filing the instant writ petition. Paragraph. Having heard the learned advocates now, the petitioners rely on an order dated May 20, 2025, passed by this court in WPA 7057 of 2025, and submit that in similar matters, writ petitions are being entertained by this court, and the state has been directed to file a report in such regard. Full stop. Having heard the learned advocates appearing for the respective parties and having considered the material on record, comma, who is the relevant respondent who should be directed?
For the filing of the report, my lord?
Yes.
Well, actually, my lord, in terms of the guidelines, my lord, all the respondents are, my lord, responsible for this, because this is a stage-wise
But
process.
report will be filed by any competent authority.
Well, that depends on them, my lord, as to.
A competent authority of the Food and Supplies Department shall file a report in the form of an affidavit.
Respondent number 3.
The respondent number 3 being the district controller, comma, food and supplies, comma, Jalpaiguri, comma, government of West Bengal, shall file a report in the form of an affidavit. Disclosing the reasons wherefore such notification advertising vacancy has been issued. Disclosing the reasons and justification wherefore such notification advertising the vacancy has been issued. Full stop. Such report shall be filed within a period of 4 weeks from date. Full stop. The petitioners shall be at liberty to take exception to such report within a week thereafter. List this matter for further consideration before the next available circuit bench immediately after expiry of the time fixed for filing of report and taking exception thereto.
Instead of respondent number 3, let it be respondent number 4.
It should actually be respondent number 4, because respondent number 4 is the licensing authority.
For subdivisional control.
Yes.
Affidavit of service to operate.
Lordship, on indulgence, like the affidavit of service be kept in record today as we have filed it. Would be very grateful. Grateful, your lordship.
My lord,
deeply obliged.
My lord, item number 47 and 41 due to technical fault, my lord, I am not appearing, my lord, by virtually, my lord.
Very well, I have made it not today, tomorrow. I mean,
Oblige your lords. Oblige your lords.
With the leave of the court, my lord, Mr. Lahiri is appearing his urgent.
I'm calling matters.
64, my lord.
So proceed.
Yes, my lord.
I am for the statement.
Passed over.
My lord, in item number 51, my lord, I am appearing on behalf of the School Service Commission. Yesterday also the matter was called. My lord, prayer was made for making not today, my lord. My lord, kindly adjourn the matter, my lord, till my lord Wednesday, my lord. But I have some personal difficulty on.
Your lordship, my senior also is busy.
But Mr. Sudip Ghosh, he is appearing on behalf of the petitioners. He is sick, my lord. He is sick, my lord. My lord, kindly take up the matter.
When do you want? When is it?
Wednesday or Thursday, your lordship? 9 or 10.
9th. When do I fix it? 9th? Tell me. 9th?
9th.
No, tariku.
Grateful. 51, 52, 53, your lordship. 53. 3. 53. No,
My lord, in 3 matters, my lord. All the 3 matters, I am for the School Service Commission.
9th. Petitioner is also not there. You are also not there, so it has to go there. 9th.
Grateful, my lord.
My lord, item number 50 was paying for not today, my lord.
Not
Lord,
today.
I beg to appear on behalf of the respondent, lordship. Respondent number 6 and 7, lordship.
Not today. Prayer has been made for making it not today.
Okay. Grateful.
Yes, Lordship, I on behalf of the petitioner, Lordship.
Yes.
This matter, happening on behalf of state, police, we have not included.
What is the matter?
Lordship, I'm paying for fertilizer license, Lordship. And the authority is the authority passed an order, Lordship. I challenge the said order, Lordship.
Where is the order?
Lordship, page number 43, Lordship.
43.
Yes, Lordship.
Forty-three is the order, yes.
Lordship is second prayer, Lordship.
So what is wrong here? You have been asked to file a fresh application upon rectification.
Yes, Lordship. But Lordship, when I filed the first application, they said my PORSA is not valid. I have rectified my application and I obtained the O form, Lordship, in the month of June of 2024, Lordship. And my application in the month of June, 3rd June 2024, Lordship. That time of O form is valid, Lordship. But now say that after prolonged time, now say that my O form is not valid. And even after
No, but they have given the reason why it is not valid.
I
They say that it is observed that one of the source certificate form O issued by wholesale dealer such and such, and from that form O has been used to apply on 27/12/2024.
Yes, Lordship.
Then
Lordship, even if Lordship, I have made when I made application, I have 4 O form is given, Lordship, in the portal side. One is not valid, then 3 is the valid, Lordship. And I challenge this, they are intentionally drag the matter, Lordship.
no, I don't find any intention to drag. There is mistake in your form. How can they proceed?
Yes, madam. That is the whole truth. They are not properly filling up the form.
You file a fresh form, as they have
Yes.
said. You file it afresh. What is the problem?
Problem is the time, Lordship. Lordship, kindly see the page number
Page
28, Lordship.
28.
Yes, Lordship. Lordship, I filed a application, Lordship. First application, they are rejected and shows that NOC and PORTA should be uploaded as per guidelines, Lordship. Then I rectified new application, Lordship. Then no remarks, Lordship.
Now they have written this.
Now
letter.
they are submission that
They have written this that they have clarified that the person whose form you have used, source you have shown, that person died in November 2024.
yes, Lordship.
So file afresh. What is the problem?
Lordship, kindly pass an order, Lordship, read maybe pending, Lordship, and I rectified in the meantime, then they issue the license, Lordship. Otherwise,
Why should I keep this pending? I'm disposing it off. You
My
file
lord,
it.
my lord, I beg to be excused. Here is the report. And the last para says what we have called from your lordship. If the applicant does not rectify, correct, edit her application through online mode using her logged in credential, the subsequent LOA issued would carry the name of dead wholesaler and other information. To avoid this apprehended.
Says you file your application, rectified application, it will be dissolved. There's no problem.
Lordship, kindly direct the, I have resolved within 1 week and direct the department to issue the license in the meantime.
Neil. The petitioner Application, how can I file time limit? You have to file the application first.
Grateful, Lordship. Lordship, may I hand it over
Take-
one copy of
Take,
instruction, Lordship?
take steps in furtherance thereof as expeditiously as possible.
Grateful, Lordship. Lordship, may I one indulgence, Lordship? Oh, one instruction may be handed over to me, Lordship.
But these are instructions. You can hand up a copy to him.
General instruction.
I have recorded whatever is there.
It is recorded there. Grateful. They will issue immediately to file.
So next.
Grateful, Lordship.
Fast over.
60,
Fast over.
61,
Fast over.
64,
All similar matters.
Fast over.
63,
Same.
66, I am appearing for the
66, my lords, I appear for the petitioner. I am led by Mr. Avinash Poddar. He is appearing online, my lords.
Please, your lordship. Lordship, I'm appearing for the
Six.
petitioner lordship in this matter.
63.
66, lordship.
66, my lords.
63 call. 63
Oh,
has
I'm
been
sorry.
called.
I'm
Apologies,
sorry.
lord. Apologies.
62, 63 are same matters.
62, 63 are same.
Yes.
Very well gone.
61, 62, 63. All these are
All-
pension based matters.
No.
Yes.
Acquisition matters. Legal requirement.
The petitioner is not
Not
there, so
there.
not today.
64,
Yes, no, 64.
Lord, I am for
My
this.
lord, I am for the petitioner in this matter. My lord,
Yes.
yesterday I was addressing your lordship on this matter.
Yes. Yes, sir. Why
My lord, may I
can the order not be fast?
My lord, DPSC is the answering respondent. Let the
Where is DPSC?
they were present yesterday.
similar order.
They were present yesterday. Today there is a resolution not to pass adverse order from 2 p.m.
7th is the last date. That is the difficulty.
7th is on Monday.
That's the last date, my lord. Understands Monday, the first month release day, my lord.
Coming.
He is coming, my lord. May I just appraise your lordship.
Let us see if your other side is there, then we can take it up today. Otherwise, Monday it will be taken up. Don't worry.
My lord, difficulty is kindly appreciates Monday is the month release day. Your lordship understands the pressures
No,
on the
no,
first
here,
day.
no monthly
No,
list.
no, here I'm saying here in the principal bench, the difficulty your lordship understands.
But then
mean,
what to do? If there is a resolution not to pass adverse order. How can I pass an adverse order?
I
So
understand
it is-
that. May I initiate in the meantime if he comes, my lord? I don't know. As
No,
Mr.
I know you don't need to repeat. I have heard you yesterday. I remember. You want to keep
Yes, ma'am.
leave for pay protection and come back. That's it.
Yes, ma'am. Only consideration of my representation till then lien to be given. That much.
Yes, I know. Because you have relied on an order of another of a coordinate bench where it was rejected, yet lien was granted. Your case is pending consideration.
Yes. But that rejection was also challenged subsequently, not in that case. The previous case that was rejected and then subsequently challenged, which is pending at the principal bench. Now, in the meantime, then DPSs were not releasing him. That is why the writ petition, which is annexed with the writ petition, was filed.
Pass over kore rakhun. If he comes back, pass over kore rakhun. Let me know if your other side has come back.
Yes, mother.
Proceed.
55, 67, 66,
Please, your lord.
the respondent, my lord.
I'm appearing for the petitioner lordship in this matter.
Union of India.
Lordship, this is a matter wherein which is covered in my own case, my lords. Lords, may please refer to P19, Annexure P19, lords. A recent order. My lords, the controversy involved is that I am an exporter, my lords.
Page 119.
Page 160, my lords. P19, Annexure P19, page 160.
Page 160.
Lordship. Lordship, this is the recent order of 16th of June 2025. Identical order may be passed in this matter also, my lords. The same facts. My lords, if I may just narrate the controversy in brief, my lords.
Yes.
My lords, the controversy in this matter is that I am an exporter, my lords. My lords, as per the scheme of law, the exporter cannot export taxes, and therefore whatever taxes are there are refunded back to the exporter. That's I filed a refund application, which was sanctioned. I got the refund orders. Now thereafter, my lords, the other side, the respondent side, had filed an appeal saying that the shipping bills were not uploaded and it was not signed by the superintendent. So thereafter, my lords, while the appeal was there, we made a request for the adjournment in the because the PH note was not received by us. In the interregnum period, my lords, they passed the order. Now, my lords, may please find the signed copy also, my lords, which is there at page number 131. Which we have already page 131, my lords. Annexure P16.
Page 131.
Yes, lordship. If at the bottom, my lords may see, the shipping bill is now approved. It is certified to be true by the superintendent.
Yes.
But we have already mailed this on 2nd of February, my lords, to the officers. If my lords may now come to the appeal which was filed, my lords, at Annexure P5, which is there at page number 46. This was the appeal filed by the other side, the respondents. Page number 46, my lords, is the copy of the postal, and page 47 starts the appeal copy, my lords. 20th July 2021. My lords have that? Page 47.
Page 47.
47, lordship. The appeal which was filed against me by the department, my lords.
Yes, I have it.
Forwarding the copy of appeal petition. Now, my
Yes.
lords, may see the date, my lords, 20th of July 2021. Now, my lords, may turn to page number 61, my lords. The only controversy in the appeal was that the shipping bill was not uploaded. My lords, my case is that the port from where the export was made, the ice gate is not working. It is not electronic port. So therefore the shipping bills are manual. And therefore, my lords, page number 61 may be seen.
Yes, page 61.
Now, my lords, page 61, the date may be seen. It is 2nd February 2022.
Yes.
I have already informed the assistant commissioner, who was the appellate authority. Subject is confirmation of export from non-EDI port of Hathisar to Bhutan. Sir, this is for your kind information that we had exported consignments from Hathisar as per the attached list. Sir, the LCS being non-EDI port, hence the shipping bills cannot be viewed in the IceGate portal. Sir, we request you to kindly verify the shipments as per the attached list and issue us confirmation, e-confirmation certificate of the shipment. My lords, I have shown the certified copies, my lords. I've just shown the certified copies, my lords. Those are the certified copies which are already certified by the superintendent against this letter. And in the meanwhile, my lords, they passed an order which is there, my lords, may find it at P7. Starts from page 62. The next page, my lords. This is the appeal order. And the relevant, my lords, may find at page number 68, the discussions and findings. And para 15, which is the concluding part, my lords, page 69, the next page, that is how the order has been passed. If I may be permitted to read, my lords. Para 15, in view of the above discussions, I am to safely conclude that the impugned refund sanction order has been passed erroneously by the sanctioning authority, in spite of the fact that the respondent has erred in declaring correct value of turnover of zero-rated supplies in the impugned refund application, hence is liable to be recalculated accordingly. The respondent has failed to upload and submit the proof of export documents. This is what is relevant, my lords, in my case, because they are saying that I failed to submit the export documents, my lords, which I have already submitted before passing this order in the mail, my lords, which was a 2nd February. Having export value of 1,52 lakhs claimed to have been exported through Hathisar LCS, and hence impugned refund sanction order is not legal and proper to this extent, and rupees so and so cannot be considered for arriving at turnover of zero-rated supply in view of the statutory provisions of section 50-51 of the Customs Act, read with notification number 40/2022, dated so and so. So this is the reason, my lords, because of which Subclause 5 may be read, my lords, the amount which was refunded to me. Thus, an amount of rupees so and so, 1 crore 7 lakhs odd, has been erroneously sanctioned in excess. That such amount of erroneous refund is liable to be recovered from the respondent along with the applicable interest under the provisions of section 73 and 50 of the said act. Now, please give me 1 minute to understand what has happened after that, my lords. After this, after the appeal order is passed, my lords, they have reinitiated the adjudication proceedings. They have issued DRC 01 capital A, which is an intimation notice under section 73 against me. Let's qua that, my lords, my submission is that once the refunds is sanctioned or rejected, in my case, the refund was sanctioned. Thereafter, my lords, the other side, the department side has filed an appeal. They got the appeal in their favor. My lords, the next stage cannot be the adjudication. The next stage has to be the tribunal, which is yet to be constituted, my lords. So what error they have done is, my lords, they have issued a fresh show cause notice, which my lords may find at P8, page number 71, my lords. Lords, my submission is that the entire appeal order needs to be passed and set aside, which has already been done by recently soon P19. All three orders are there. Wherein, please, Your Lordship.
You were
Am I audible?
You were inaudible in between. I couldn't hear what you said.
I'm extremely sorry. I'm extremely sorry. But my submission was, I was trying to submit that the appeal order has been passed, my lords. After the appeal order, they have reinitiated the proceedings. My lords, my submission is that the appeal order was passed without hearing me, without considering the documents which I have already submitted, because you know this was a non-EDI port, so nothing was being reflected in the ICE gate. The shipping bills were manual, which were manually certified by the superintendent, which I have just shown to my lords. So in my identical cases, which are annexed at P17, P18, and P19, this honorable court has quashed and set aside the appeal order, and they have remanded it back to the appellate authority to consider now the shipping bills so that they can consider it afresh and pass a fresh order after giving me opportunity. This is one, my lords. Second, my lords, what they've done after appeal order, the course should be that if I am aggrieved, I'll go to the tribunal. If they are aggrieved, then they have to go to tribunal. What they've done is, my lords, they have initiated a fresh proceeding, which my lords may find at page 71. Page 71, my lords. They have reinitiated, they have issued a show cause notice, my lords. Because, my lords, as per my submission, my lords, the appeal order can be challenged at a higher forum. Appeal order cannot be a reinitiation of a proceeding. My lords, please see what they are trying to write. Page 71, my lords, they are saying, please refer to the appeal order dated so and so, which is impugned, issued by the additional commissioner. Now, additional commissioner is a superior authority to this officer who is issuing the show cause notice, who is an assistant commissioner. Siliguri Appellate Commissionerate, Siliguri. In this regard, the amount of tax interest penalty payable by you under section 73, as amended, read with so and so provisions as amended, as ascertained by the undersigned in terms of the available information, is given below. Now, he issued a pre-intimation show cause, my lords. Thereafter, my lords, may please see the show cause notice, which is there at page number 74. The detailed show cause notice, which is also emerging from the same. It is also emerging from the appeal order, my lords. And then they have passed the order, my lords, which my lords may find at page number 84. Now, how an assistant commissioner can pass an order against the appeal order, my lords? That is the submission, page 84, my lords. Is the fresh order demanding the tax, interest, and penalty. Whereas the appellate authority has already demanded.
This has been passed after the appellate order.
Lordship pleases, Lordship pleases. So therefore, my submissions are twofold, my lords. One, my lords, I'm requesting this honorable court to send me to quash and set aside the appeal order and the subsequent proceedings, and send me back to the appellate authority to consider the shipping bills which are already now approved and certified by the superintendent. And after considering that, they can pass an appropriate order, my lords, which is already given by this honorable court, lords. If my lords may see. P19 for a moment, which I have already shown, my lords, page 160. My lords have page 160.
Yes.
If I may read, my lords, the petitioner has filed the present writ petition seeking quashing and setting aside of the order dated so and so passed by the additional commissioner CGST and Central Excise Siliguri Appeal Commissionerate under section 10711 of the CGST Act. By the impugned order, respondent number 2 reversed the order of dated so and so passed by Assistant Commissioner, whereby the petitioner's refund was allowed. The petitioner is engaged in the business of so and so. This is not relevant. I'm coming to para 3 directly. The petitioner has filed a refund application dated so and so, claiming a refund of so and so amount. The said claim was allowed by respondent number 4 by order dated so and so. Subsequently, the refund order was challenged by the departmental authorities by way of an appeal before respondent number 2 in GST appeal number so and so. The said appeal was allowed by respondent number 2 by order dated 24/1/2023, directing recovery of so and so from the petitioner. Now, my lords, thereafter the petitioner was served with a series of proceedings including show cause notice dated so and so, order dated so and so, summary of the order dated so and so, which I have just shown, and the recovery notice dated so and so. Although the impugned order dated so and so is appealable.
Yes, I've seen it. I've seen it.
But
Yes,
the similar
number
order.
one.
Yes, Lordship.
Yes, what is your submission?
Lordship, actually, the appellate authority, because whatever learned counsel is saying that superior officer's order, the lower authority cannot act upon because he is the appellate authority. It is not the designation because he is sitting in the appeal. So that's why in the order itself, in the appeal, page 70 can find there is a direction. Page 70, Roman 5. Thus, an amount of rupees such and such has been erroneously sanctioned, that such amount erroneously remitted is liable to be recovered from the respondent along with the applicant interest under section 73. And rightly, this the order of the appellate authority is being followed because his designation is not material, Lordship here. Anyway, but previously there is the judgment. I'm just only inferring some of the relevant paras, which may be because whatever Mr. Poddar is saying. And another thing is the personal hearing, kindly see page 68. There is some different thing is stated by the appellate authority. 68, I will just make only 1 minute submission, Lordship. I will not trouble much.
I'm keeping this on Monday because there is no time left today.
Lordship.
No, Lordship, I am agree that but the order can
Very
be.
well, but I'll take time to pass orders, which
Yes.
I don't have today.
Monday it may be kept.
Then Tuesday, Lordship. Monday I am out of station.
Tuesday.
Lordship.
All learned advocates appearing for the respective parties. Let this matter appear for further consideration on July 8.
Lordship.
My lord, may I be permitted?
Lordship.
My lord, may
64. Mr. Lahiri.
my lord, I think he is not present, my lord. I think he is not present. So, my lord, may I only seek some precedence over the matter since 7th is the last date?
Yes, it
Can
will
it
be
be at
taken up.
top, my lord?
It will be taken up. You bring your other side. If he's here, I'll take it up.
My lord,
Not today, my lord. My lord, Monday. Can it be at the top, my lord? Can it be at the top? Because, my lord,
I'm
for
not
orders.
upgrading. I'm not upgrading, Mr. Lahiri. If in case I'm not able to reach, you mention it with your other side, I'll take it up. Since it is the last day.
I'm extremely grateful, my lord.
my lord, may I be permitted to mention a matter, my lord? I had mentioned in the morning. My lord, it is a hearing matter, my lord, but my lord, only a short point is required, my lord. If it
Hearing
could-
matter, I said, please mention next week.
और पोदार जी कैसे हैं?
बढ़िया सर, आप कैसे हैं?
बस फर्स्ट क्लास अक्रॉस द टेबल है। चलिए बढ़िया ही है।